and welcome everybody. Happy 2023 to all the honorable members here at M46 and on the virtual. I want to welcome the public protector and her legal team in the resumption of our inquiry. You're welcome, public protector and your legal team. To also acknowledge our evidence leaders, Advocate Bawan Mayosi, to welcome members of the media with us as we start our session in 2023, the entire support staff, and a special welcome to members of the public who probably would have felt a very long holiday and break, couldn't wait to restart. We are back, but let me also acknowledge, and I hope that we will to acknowledge Miss Sokoni, who would have been with us in our last session. You would have taken an oath. You're still under oath. We're not going to repeat that. Thank you very much and welcome. Today, dear colleagues, as we ended on the 5th of December, we are resuming our inquiry, and we are still under the leadership of the public protector legal team in leading evidence of the remaining witnesses. I'm now going to take this opportunity to invite Advocate Mpofu to resume the leading of evidence with Ms. Sokoni, who would have been with us at the start of this inquiry. Quite a coincidence. And I hope that as Advocate Mpofu starts, I see quite a number of other guests joining. I'm not in a position to say who they are. He will be able to indicate that, but you're all welcome. Thank you very much. I can see he's still busy on social media. Over to you, Advocate Mpofu.
I missed that, Chairperson. Okay. Thank you. Good morning, everyone. Chair. Good morning, everybody. And
let's pause there.
There's music.
Somebody else. This time go chabalala pemva kwakho. Sabotage this week. Yeah.
Shabalala out of order. I think we'll call the white shirts. No, good morning, Chairperson, and good morning, members and everyone, evidence leaders.
My apology, just a pause.
Sure.
I just forgot to indicate, colleagues, that we have Ms. Zulu-Sokoni for today and tomorrow, and today will be a day dedicated and to the public protector team. We'll start now until the end of the day, so to indicate that if he doesn't need that, it will be a very good sign. We would then start tomorrow with evidence leaders half a day and conclude with the members at the end of the day. You're indicating that you don't need such long much time.
Chairperson, I'm sorry to disappoint you. No, I'm indicating that I might need more time, Chairperson, but we can maybe offline, you and I, during tea, we'll talk about it and see if we can find each other. But on a serious note, Chairperson, it's my assessment is that we might even have to spill over, as I indicated in the letter, maybe to Wednesday. Obviously, it's not as a target, but but we'll talk over tea time. Yes, Chair, I was just saying that I hope everyone had a good break, and I'm sure those who were in the conference, that its conference went well, and we are here to start on a fresh start. So, Chair, if I may, if you just give me 1 minute, I had indicated to you via correspondence that there were certain issues that I wanted to address, which in our backroom meeting with the evidence leaders, we had hoped would save us a lot of time, not necessarily today or tomorrow, but I'm talking in general. You indicated in your letter, Chair, and I suppose that's confirmed by what I've just said about the witness, maybe even having to take longer. That so I'm in a way agreeing with your approach, Chair, which was that such matters, insofar as they're not directly involving this particular witness, can be dealt with at the end of her evidence. So we will follow that wise approach from the Chair, so that even if we spill over, we don't overspill, so to speak. Yeah. So therefore, Chair, we will immediately start with the business of the day. And then we'll deal with our domestic issues once our guests have finished their business. Now, Chair, you correctly indicated that we have, I think one can say, in the world of public protectors or ombudsman, as the institution is known internationally. Today we have the ombudsman royalty with us. As you indicated, Chair, I'll introduce them. The first person I'll introduce is the one just next to me. That's Honorable Florence Kajuju. As you indicate, she was here earlier in these proceedings. She is an advocate herself. She's from Kenya, she's a former vice chair of LSK. I'll find out just now what that means. And she's the most important head. She has many, many heads, but the most important one is that she's the president of the IOI, which is the international body that effectively more than almost 140 countries now affiliate to. She has obviously herself has experience in this field, and we are deeply honored. We also were pleasantly surprised when she indicated that she could come today to give support to Honorable Sokoni. She's not alone. She's with the Miss Mercy Wambua, correct? Yes, sitting next to her. She's the executive director of AOMA, which is the African version of it's the continental body. We'll talk about these structures when we lead the evidence, Chair, in more detail. And she's also the CEO of CAJ. And executive director, as we all know in those structures, is the person who runs the operations, which is basically the CEO. And then, of course, we have Honorable Sokoni, who's the public protector of Zambia, but also here wearing her cap as representing AOMA. Although she'll also touch on the comparative issues of the public protector of Zambia, as indicated in a statement. And then, of course, last but not least, we have the public protector of South Africa, who is an active participant in all those structures and is an esteemed colleague of these. It looks like, Chair, a lot of us can learn a lot from these organizations, not just about ombudsman, but also about women empowerment. So
no, thank you. You are all welcome, both in South Africa and at this inquiry. Thank you very much, and thank you, Advocate Mbof.
Thank you, Chair. Yes, as you indicated, Chair, Honorable Sokoni has already been sworn in. So this is the part where we deal with the formal evidence. Good morning, Honorable Sokoni.
Good morning.
How are
Good
you
morning.
today?
Fine, thank you.
Okay, if you can try and speak up or closer to the mic.
There are two mics there. Is there a mic that side?
So you'd like them to both be
Because
on?
you'll be looking at him most of the time.
Yes.
Oh,
Better to like
So that will be the mic that will work, the other one on the other side. Or is there just one mic? Yes. So that we don't finish a day with a sore neck. Thank you. I hope it will work.
actually, because
Okay.
I think it doesn't make a difference.
Are you well, madam?
Yes, very well, thank you.
Thank you. Welcome back. As the chair has indicated. I just want to firstly to indicate, and I'm sure it will be clear very soon after a few questions, the importance.
Just a pause. Advocate
Okay,
Mbof.
okay, Chair.
We want her to be as comfortable as she can be,
Yes.
trying to, so that you can shift the chair just towards that other mic.
Thank you. Is that comfortable?
Yes, yes, thank you.
Thank you. All right. Now I was saying that it will become clear after a few questions that this is possibly one of the most important testimonies that will be given to this committee, because it's going to give us context. And you and I, as lawyers, we know that the catchphrase that says context is everything. So you're going to be giving us the historical context and the specific context of this important institution of democracy around the world. Now, I want to start by just going back in time, because you were here with us before, and remind you that we had the very first witness. I don't know if you were here for that witness or you were only here for Mr. Samuel, but the very first witness who testified here was a gentleman called Mr. Ibrahim, who in a way at least promised to give us some of the context that you are giving us. But it turned out that he said himself that he was not an expert. So that was the end of his usefulness for this purpose. But more importantly, he also said something which I would like to pose to you as the first question. He said there are no experts in this field of ombudsman. He was trying to justify why he's just a constitutional expert, but there are no real experts. Is that true?
The institution of the ombudsman has existed for over 200 years. There's a lot of jurisprudence in that area. There's a lot of books that have been written on ombudsmanship. So we have a number of experts in Africa. We have our own Professor Ayeni. We have former ombudspersons like Justice Florence Mumba of Zambia, who has written a number of articles in a number of books regarding ombudsmanship. We have Professor Linda Reeve, who has written a number of books on ombudsmanship. And there's a plethora of papers that have been written by a number of ombudsmen at different International Ombudsman Institute conferences, as well as African Ombudsman and Mediators Associations conferences. So I think that's my submission on that question.
Yeah. No, thank you. I'm sure Mr. Ibrahim was not deliberately misleading us or the committee, but I think that statement just underscores the fact that of his first admission that he himself was not an expert in the field. Otherwise, he would have been aware of those African and international experts in the field, correct?
No, that is correct.
Thank you. All right. Well, now that we have a real expert, we can then try and demonstrate the extent of your expertise in this field. And I will take you immediately to your statement, which is at 213, I think. Sorry, I'll ask my colleague to help me to identify this. I know that the affidavit is bundle H is 31.3. Am I right? Aye. There you are. Maybe just so that we don't go word for word on this, just to explain to those people, unlike the members who have seen the statement, just to explain to anyone else that the structure of your evidence is that you've given a short affidavit to which you have attached quite a detailed statement. And so we'll go through the affidavit just to really put everything in its proper context. But most of my questions will emanate from the statement itself. So could you then just give the committee briefly your academic qualifications first?
I have a Bachelor's of Laws degree. I have a Bachelor of Laws degree from the University of Zambia.
Recording stopped.
And a Master's of Law degree.
Recording in
from
progress.
the University of London. I have been ombudsman in the Republic of Zambia for the last 18 years, from 2004 to the present.
Sorry, from 2004.
Yes.
So next year you'll be 20 years in the office.
Yes. Yes. I have served as AOMA regional coordinator
Mhm.
for Southern Africa. I served in that position for 4 years. I then served as AOMA treasurer for 2 years. And subsequently, I was also elected to the International Ombudsman Institute to sit as director on the board of directors. I served as IOI Africa director, again for 4 years. And I currently serve as the IOI treasurer, that is the International Ombudsman Institute treasurer. The International Ombudsman Institute is the world body of ombudsman institutions. And its secretariat is housed in Vienna, Austria, by the Austrian Ombudsman. And the African Ombudsman and Mediators Association is the Africa-wide association of ombudspersons. It has been in existence formally since 1995, formally, yes.
Okay. That's good. So it would be safe then to say that you have served the institution, and I mean broadly the ombudsman and institution for a long time at a national level, at a continental level, as well as an international level.
That is correct.
Thank you. And you have held the position, some of which you have mentioned now, and others which are covered in your statement.
Yes, that is correct.
All right. Now, can you then just tell the committee briefly about IOMA and IOI? You know, just briefly, what do they stand for? Not the letters. Well, you can also tell us about the letters IOI and IOMA, but broadly, what are those bodies? I think we have a fair idea of what the Public Protector of Zambia may be, because it's not much different to ours, and we will deal with the comparisons later. But those other institutions, if you can just introduce them to the committee.
Thank you so much. The International Ombudsman Institute was set up in as way back as I think 1991. And it was established in order to standardize the operations of ombudspersons worldwide, also to ensure protection for the institution of the ombudsman, because it is a very unique institution. It is not like no other human rights institution, because by its design, it is intended to investigate the very institutions that create it. So it was felt necessary to ensure that there was sufficient protection for the ombudsman in its operation, and also to have international recognition from the United Nations and other international regional bodies to extend the appropriate protection, and to establish appropriate standards for the operation of the ombudsman.
That's the IOI.
That is the IOI.
And IOMA?
For the African Ombudsman and Mediators Association, they actually started the operations initially by establishing a research institute at the University of Dar es Salaam. And when the institution of the Ombudsman in Tanzania became a hybrid institution investigating maladministration as well as human rights, it was felt that it was necessary to move the institution of the ombudsman to a jurisdiction which was more reflecting more of classical ombudsman style. That was the time, I think in 2005, that there was an African Ombudsman Association meeting, because initially the institution was called the African Ombudsman Association. So when we met at Misty Hills in Johannesburg, it was there that the African Ombudsman Association was transformed to the African Ombudsman and Mediators Association, to try and embrace also French-speaking Africa, because in French-speaking countries, the institution of the ombudsman is known, they refer to it as the mediator. So the name was transformed from African Ombudsman Association to African Ombudsman Mediators Association, and the constitution amended. And it was at that point, actually, that we also started talking about the need to have standards, because it was noticed that there were a lot of ombudsman institutions that were not being properly recognized in their countries. They were not being accorded the proper protections. And it was at that time that we started the discussion of the issue of drafting standards as to what sort of what sort of ombudsman institutions we needed in a constitutional democracy in Africa. A lot of the countries were establishing hybrid ombudsman institutions. And when I talk about a hybrid ombudsman institution, like I said, in Tanzania, they had to move away from Tanzania to South Africa because Tanzania had a hybrid ombudsman institution. A classical ombudsman institution has a single mandate, that is the investigation of maladministration, and it is accountable to the legislature. And thirdly, and most importantly, its reports have the force of a recommendation. They are not binding. Yes, please.
Thank you very much. And you'll forgive me, I'll be jumping between your statement and the affidavit so that we save time. So if you touch on something which I was going to touch on later, I'll wrap it up now so that when we get to that stage, we don't have to redo it. And I'm saying that apropos your statement which you just made now about French Africa. And so we might as well just deal with the terminology up front, because I'm sure some people who are not familiar with this field, which is new to us, we're a young democracy, but sometimes we think highly of ourselves. But we might assume that people know that ombudsman means the same thing as public protector and so on. So I'll take you directly to paragraph 12 of your statement, which you will find at 31.3.2. And while they're putting it up, let me just ask you this question. It is indeed so that the ombudsman is a generic term, and each country uses whatever term pleases them, but they all fall under the generic description of ombudsman, and we'll get into the history, but can you just confirm that?
Yes, the term ombudsman is a Swedish term, meaning,
Swedish.
Yes, meaning a defender of rights or a people's protector. Yes. So different jurisdictions have then embraced the concept of the ombudsman, but it's an institution that is for the vulnerable, for the least person who needs to hold government to account when an injustice has been occasioned against him. So it therefore became necessary, different jurisdictions recognized that we have to, in order to entrench this concept in our jurisdictions, the people have to own it. And the people can only own it if they understand the term that you are using to call this very important office.
Yeah.
So in French-speaking countries, they refer to this office as the mediateur, but I am aware that they do translate it into local languages as well, places like Senegal, the Gabon, for people to understand. And at the same time, some countries, like for instance, those which have merged the mandates, like the Inspector General of Government in Uganda, they refer to the Ombudsman as the Inspector General of Government. In Angola, in Portuguese-speaking countries, they call it the Provedora de Justica, meaning the provider of justice. But I must state at this point that the concept of the ombudsman seems to have some sort of different impact in civil law countries and in common law countries. So in the civil law countries, they have what they refer to judges as a judge investigator, because judges in the civil law countries tend to go out and investigate, carry out interviews, collect the evidence, and then this is when they sit to actually hear the case. Whereas in common law jurisdictions, a judge is an independent arbiter who hears both parties. And after he has heard both parties, he comes to a conclusion. He is not a part of the collection of the evidence. So I think that even the Scandinavian countries had that sort of background. And when they were establishing the office of the ombudsman, they were establishing the office of a judge investigator. They gave this office the power of a judge investigator. So you find that even our colleagues in French-speaking countries accord their ombudspersons the status of a judge. I do recall that at one time in Zambia, we hosted a training for French and English-speaking countries, and we called our Chief Justice to as the guest of honor, and they were saying, no, but in our country, the ombudsman, the mediator is senior to the Chief Justice or on par. So this is from the civil law point of view. But when you come to the common law countries, this concept of the ombudsman being on the same status as a judge is not taken as so. I think even for countries like the United Kingdom, they have to grapple with the same issues.
Thank you. Yes.
So just a small difference, just a bit of information about the office. There's so much confusion, and this is the reason why there has been a growing need. You have seen a growing body of international instruments, the Venice Principles, the IOR Tambo Declaration, the flurry of UN resolutions to try and see if they can find a middle ground to ensure that this office is properly established, standardized.
Okay, thank you. Now I was laughing because I would have preferred you to tell the story in its original form. You don't be diplomatic. When you told us the story, you said when you invited the Chief Justice, one of your colleagues said, "Why did you invite your junior?" Isn't that how it happened?
Well, if my recollection is correct.
Yes, thank you. But yeah, no, but that shows on a more serious note, the point you're making that different jurisdictions have different models, but the general principle is the same, correct?
Yes.
And just a little bit of trivia, because we all don't want to be sexist. We all get into the habit of saying ombudsperson, but I was told some years ago that's actually wrong, because the man in ombudsman doesn't mean a man. It's ombudsman is actually a translation of Swedish, the Swedish language, which, as you correctly say, means the defender of rights or the people's protector. Correct?
Yes, yes, that is correct.
Yes. And therefore we can be proud, I think, as South Africans and Zambians, that we probably have the closest translation of the original word ombudsman in people's protector or public protector, correct?
Yes, yes, yes.
And that paragraph that I wanted to show you, paragraph 12, just covers some of the information that you've given us, where you say, I'll just read it out for progress, Chair. You say, over time, several countries have established the ombudsman institutions in Africa, albeit under different names. In French-speaking countries in Africa, Francophone, the Office of Ombudsman is referred to as Mediator de la République, which means a mediator of the Republic. Whilst in Portuguese-speaking African countries, it is called Provedor de Justiça, which means the provider of justice. In Uganda, it's called Inspector General of Government. In Kenya and Tanzania, the Office of Ombudsman is styled and named as a Commission for Administrative Justice. And you say, according to Professor Ayeni, one of the experts you referred to earlier, countries choose organizational names other than ombudsman to communicate the purpose of the organization and give the institution an identity that citizens of the countries concerned can associate with. So that captures the information you just gave us.
Yes, thank you.
Thank you very much. All right. Now, going back to your affidavit and your credentials per se, you have also given an indication of a structure called IOC, African Ombudsman Research Center, with which you are associated, and I think all three of you public protectors and leaders in that space are associated with it. What is that institute? And I'm singling it out because it happens to be based here in South Africa, and you can also tell us how that came about.
Thank you so much. When the research center was moved from Dar es Salaam to South Africa, it was found necessary to establish a formal secretariat for the institution of the ombudsman. And as we were establishing this secretariat, it was felt that it should also be established in such a way that it can be sustainable. It can be a self-sustaining institution, secretariat. So it was thought that there was need, if it was going to be self-sustaining, it was going to be carrying out research, carrying out consultancies, then we needed to establish an institution which was sort of like separate, but still under the arm of AOMA. So it was then decided by the executive of the African Ombudsman and Mediators Association to establish AOC as a research institute with corporate legal personality. Mm-hmm. So it was then established in 2011 as a research and training arm of AOMA. And it has a board, and this board is chaired by the Public Protector of South Africa. In a way, it mirrors the International Ombudsman Institution, except that the International Ombudsman Institution did not establish a separate research arm, but the chairperson of the of AOC is permanently the South African Public Protector, just as the permanent Secretary General of the International Ombudsman Institute in Vienna is the Chief Ombudsman of Austria. So the African Ombudsman and Research has entered into various memorandum of understandings with the different organizations. Chief among them is the cooperation which it has entered into with the International Ombudsman Institute. By entering into this cooperation with the International Ombudsman Institute, it has been hosting conferences for training the whole of Africa, African ombudsman staff and African ombudsman themselves. And it has also, during the COVID era, I'm proud to say that AOC was the most active ombudsman center in the whole world. I think it was hosting webinars almost every month. And these were being attended by online by ombudsman institutions from each and every continent. Now, why the African Ombudsman Research Center is also very, very important is that with the Secretariat being registered here in South Africa, we were able to also harness cooperation with the South African government, and the South African government has been actually funding the African Ombudsman and Research Center. And if it was not for the inputs and the sacrifice of the South African government, the African Ombudsman and Research Center would not have been able to have such a big impact, not only on the African continent, but internationally as well.
Thank you. No, thank you very, very much. And I think the parallel with South Africa, the role that South Africa plays is the same as the role that Austria plays at the international level. Can you explain that briefly?
Yes, the Austrian government has accorded the International Ombudsman Institute support in that it pays for the staff who man the secretariats of the International Ombudsman Institute. And as well as that, it also has given a budget to the International Ombudsman Institute. So all the members of the International Ombudsman Institute pay subscriptions to the Secretariat. And from those subscriptions, that money is used only for trainings and for regional activities to improve and encourage ombudsmanship in regions throughout the world. The International Ombudsman Institute has got 5 regions: Africa, North America, South America, Latin America, and the Australasia region as well. So without the support from the Austrian government, the International Ombudsman Institute would have found it very difficult actually to coordinate the international activities that it does. Pre-COVID, the International Ombudsman Institute was hosting about 2 or 3 trainings per year for ombudsman institutions. So our AOC, as the Secretariat of AOMA, is also playing a similar role for African ombudsman institutions.
Yes. And that then takes me to something that, well, let's start with the OR Tambo Declaration. At paragraph 14 of your affidavit, you then refer to something called the OR Tambo Declaration on the minimum standards for an effective ombudsman institution. What is that?
You will recall, I think when I commenced my evidence that from 2005, when the African Ombudsman Association transformed to the African Ombudsman and Mediators Association, it was resolved that we needed to standardize the principles, ethics of ombudsman institutions in Africa. It was very difficult. I'll speak even from a personal perspective. It was very difficult for me to explain to my government that I could not be accountable to the executive and investigate the executive. And we needed to move away from being an executive ombudsman to a parliamentary ombudsman. So we wanted to have standards, continental standards, which would assist ombudsman officers when they were having problems with their governments, to be able to say these are the standards for the African continent. And this is what we need to do to improve the performance of the ombudsman institution in our country. So I'm very happy to say that I was part and parcel of the team that was actually drafting the OR Tambo minimum standards for an effective ombudsman institution. And they were launched in 2014. And by 2016, it helped me as well to lobby my own government when we were establishing the parliamentary ombudsman system. And by 2016, Zambia had transformed from an executive ombudsman institution to a parliamentary ombudsman system. And I hope that it has also helped a lot of other African countries in ensuring that they have a properly constituted ombudsman office in their jurisdictions.
Okay, thank you very much. And maybe again, just for the sake of progress, if you allow me, so that we don't have to come back to that topic, to just jump to that declaration, which is obviously important for the continent and South Africa, given its origin and even its name. Can we go to page, I think it's 266. Yes. Now, that's the OR Tambo Declaration on the minimum standards that you just explained to us, correct?
Yes, correct.
And if you can, just to confirm what you were saying, let's go to right at the end. I will come back to 266. Let's go to 271, please, Tsepa. The signatures. Yes. So just go further down a little bit. Or up, if that's down, then go up. Yeah, okay, thanks. Yeah, and you're saying this document was adopted at OR Tambo International Airport, 26 February 2014, and it's signed by, I suppose, the then president of AOMA.
Yes, Dr. Paolo Chipilika.
Okay, and who's from where?
He was the Provedora de Justica for Angola.
From Angola, yes.
Yes.
And then it was signed by the Public Protector of South Africa, then Advocate Tuli Madonsela, who's, I'm sure will tell us more about it. She's going to be one of our witnesses. Was that also to recognize the role that you say South Africa plays in this entire project?
At the time, the Public Protector South Africa was both chairperson of the African Ombudsman Research Center, as well as executive secretary. At the time, the position of Secretary General was called Executive Secretary of the African Ombudsman and Mediators Association. So she signed in her capacity as Executive Secretary of AOMA.
Good. And all right, now let's go back to 266. Thank you. And against this, before I ask you specifically, when I was asking you earlier about the importance of these international institutions, the word that you used the most was the word protection. Why is that an important issue? The issue of the protection of incumbents or ombudsman offices?
As I explained earlier, the institution of the Ombudsman is very unique in that it is a creature of political will. The government of the day has to allow for the institution to be created. Of course, public awareness, also increasingly public awareness, and a call, just a general call from the people for an institution which supports the ordinary man has also helped. The wind of change of democracy has also helped to instate this institution in various countries. But once the institution is created, there are a lot of underlying problems in order for the ombudsman to be able to operate independently. So you can, if you look at all the instruments that I have quoted, not just the OR Tambo, the Venice Principles, the IOI bylaws, the United Nations resolutions, they all talk about the need to protect the independence of the ombudsman, because the ombudsman investigates the very office which created it and the very office which funds it and the very office which is supposed to pay the salary of all the salaries of the members of staff and the ombudsman himself. So you find, I think I can speak from experience, you find that the institution of the ombudsman will not be properly funded. It will probably be the least funded. And yet the institution is supposed to investigate the executive, whether it's parastatals, whether it's ministries, ministers, PSs, permanent secretaries. This ombudsman is supposed to investigate all these people. So the first thing you find that there is underfunding. The second issue, maybe you find that, which happened in my case, the ombudsman reports to the executive. And if the government does not accord the ombudsman the appropriate status, you will find that the ombudsman is in the civil service salary scale, and the head of the civil service is his boss. And when the officers from the ombudsman go to investigate the various officials, they are even threatened and told, how can you investigate your boss? You know, And you find that a lot of the members of staff in some instances are drawn from the civil service. So the members of staff start to fear that I will not be promoted, I'll be demoted, because they are within the structure of the civil service. So it became necessary to set up standards to say even the staff of the ombudsman must be appointed by the ombudsman and must be not drawn from the civil service. So other threats to the institution include also reprisals to the ombudsman himself, political reprisals to the ombudsman himself. So the conditions of service of the ombudsman may be tampered with. You may find that the ombudsman is not able to, even if he has the powers to access documents and other things, he may not be able to access documents, even if it's in the law, but it may not be possible. So you find that in a lot of jurisdictions, they say the ombudsman is a toothless dog, because they say that the ombudsman is supposed to be the public service watchdog. But the executive which establishes it is the one that is supposed to give it teeth.
Yes.
And by its very nature, and this is the reason why in the classical example, the ombudsman reports to the legislature in order to separate the issue of the ombudsman having a conflict of interest, being accountable to the very office it was established to investigate.
Yes. Thank you very much. Well, if we can just pause on that, and that I'll just ask you to maybe, insofar as you may, comment on this, because that issue that you have raised features very prominently in this inquiry that we're having here in various ways. But let me just give you one example. And as I said, we are a young democracy. Maybe we can learn a thing or two, and maybe we can make the necessary adjustments. Learning also, and everyone has accepted here that this process is also for us to learn as a country. Now, in our situation, against the background that you have mapped, we have a strange situation where a member of the executive, for example, is given the power in terms of section 194(3)(a) to suspend the public protector, basically in his or her own discretion, even in a situation where the public protector is investigating that person. Is that a good thing that is in line with the protections that you are talking about at a general level? An unfettered power to suspend at the hand of the executive. And if I will give you a comparative situation with judges, where that situation is quite different. But as far as the public protector is concerned, there isn't. Sorry.
Just a pause, Alfred Mbof. Just a pause.
Okay, without even finishing my sentence.
Advocate
Sorry,
Bauer.
I'm sorry I interrupted you. Finish your sentence, Advocate Mbof.
No, it's
Sorry,
fine.
Chair, I mean,
No, I've now recognized you.
sorry, Chair, I thought that maybe in not wanting to get into an argument or debate with my colleague, that maybe it should be appropriately stated to the witness that it's not just a member of the executive, but it's the president.
Yes, well, even worse, yes, that's correct. Even worse, the president, the most powerful member of the executive, thank you, has the power to suspend the ombudsman And in our situation, in an act that one of our courts has labeled as retaliatory, because what had happened is that the public protector had issued certain questions to the president, and then she was suspended the following day. But that's the background. But the question I was putting to you is a more general, without getting into the specifics of that case. I'm saying in terms of the what you call the standards, the accepted standards, and the need for protection, which you have emphasized. Would you say that situation where a member of the executive and the most important member or most powerful member of the executive has got that power without even, and I think it's in one of the countries will come to that, without even having to get the confirmation of parliament, for example, is that a good thing?
I will state that according to ombudsman standards, we talk about the principles, applying the principles of natural justice, and we insist on procedural fairness in our work. And this insistence on applying the principles of natural justice and procedural fairness does not just extend to the ombudsman when the ombudsman is investigating. It extends to the relationships of the ombudsman and his members of staff. Whatever he does, he must be guided by the principles of natural justice. Those are our tools, our working tools, and by the concept of procedural fairness at all times. And even in our administrative interactions with, whether it is the executive, whether it is with the judiciary, or whether it is with the legislature, that is the standard that we use. And if that is the standard that we use, then I expect that the different arms of government will recognize that, and they will also insist on adhering to the same high standards of procedural fairness. But of course, it's a work in progress. In all jurisdictions, it's a work in progress.
Yes, thank you. All right, maybe let me put it this way. Again, if we try to keep it at the general level, let's assume you have 3 countries. Let's call it country A, country B, and country C. In country A, before the public protector can be suspended, there is a system where you have to get confirmation from parliament. And as I say, I know it's one of the countries, I'll give you that example. Okay, so that's country A. In country B, there has to be, or rather, even the suspension itself is done by an independent body of judges or whatever, whatever independent body. And in country C, the president can just suspend you without those 2 protections. Which, according to the things that you are telling us, which of those is the worst system?
Of course, the third one is
Yes.
the worst system, but I must state that because we're talking about the institution of the ombudsman, it is absolutely necessary when any of the arms of government is dealing with any issue regarding the ombudsman, that procedural fairness must apply, because the ombudsman is in a very vulnerable position. As I said before, the ombudsman investigates the executive.
Yes.
So it's absolutely necessary to accord the ombudsman the highest levels of procedural fairness available. It's one person operating in an office as a legal entity, and the responsibility of making final decisions for all the investigations in the institution lies upon the shoulder of that officer. It's not easy. It's very, very stressful, speaking from experience. So the ombudsman must be accorded the highest level of how should I put it? Administrative and legal support to ensure that there is procedural fairness when any issue to deal with the institution is under the purview of any of the arms of government. So you said in the first instance, where there is a suspension, which is subject to a process and another process. So I would suppose that first that process must be completed before any decision can be made to accord any sort of decision with regard to that office holder. And in the second instance where the body is completely independent, I assume that all the proper procedures are in place, and the office holder would not have any complaint really with the process. And then with this country, you see where the president just suspends arbitrarily. Obviously, there isn't a proper ombudsman system in place.
Yeah.
You can't even really categorize it as there being an ombudsman in that country if there is such a situation.
Yes.
And I will say that we have had applications like at the International Ombudsman Institute from countries where the ombudsman is appointed and dismissed by the executive. And normally, according to our criteria, we don't accept membership of such countries.
Okay, that's, thank you. You've taken me to my next question. So again, we're talking about some country somewhere in the air. If it was to be found in that country, that's something like what you and I have described, which doesn't really accord with how the institution of ombudsman should be run. Am I understanding you to say that that country might face the possibility of being expelled? Maybe that's a strong word, but at least not being accepted into the family of ombudsman institutions in the world. Let's say there was let's use your country. If in Zambia, tomorrow they come up with measures which clearly are not in accordance with the minimum standards, would that risk expulsion from IOI and that kind of thing?
Such decisions are not taken very liberally. They are there's usually a lot of toing and froing.
I assume the toing and froing is done, so then what would be the worst thing that could happen? in
Yes,
such a
the
case?
worst that can happen is expulsion.
Okay. Thank you. Now, you talked about reprisals
Yes.
as one of the, and we're still on the subject of protection. Yeah. Looks like one of your themes is that there must be these instruments, if you summarize them, all call for maximum protection of ombudsman incumbents and offices for the reasons that you've explained, because the office is inherently vulnerable and it investigates very, very powerful people.
Yes.
Now, and institutions, yeah. This is what I want to get at, and I'm just cutting to the chase so that I can be sure that my country is not going to be expelled. We have the following situation here, and if you go to, oh no, let me start by saying this, which is more important. Is it correct that in your explanation of the separation of powers earlier, you said that Parliament, and again, we're talking in general terms, should actually be protecting the public protector?
Let me start by saying that, of course, there are different systems the world over. But if we're talking about the classical model, the ombudsman is accountable to Parliament, is appointed by Parliament, and can be dismissed from office by Parliament in the classical model. Yes. Now, I think it was not envisaged that a situation would arise where an ombudsman really needs to be disciplined unless they've really grossly misconducted themselves, because the way the classical model is designed, the ombudsman has the unfettered powers of a judge during the course of investigations. So in order for you to be able to get the information, to get the evidence, you have to use those powers until the point where you are issuing the reports. Then those powers drop from you. You issue a report where you only make recommendations. And the reason why that is so was to prevent the ombudsman from always being in continuous litigation if they were made to have binding powers. And also, the second reason is just to ensure that there can be no acts of retribution from the executive, no harassment, because then the recommendations are just so, they are recommendations. If the executive wants, they can ignore those recommendations. And then the ombudsman now has the added protection of going to Parliament to say, I issued this report, and the respondent is not willing to implement the recommendations. And then it would then have to be up to Parliament to send this matter to a committee, which would then engage the respondent institution to ensure compliance. So in a classical model, it was never envisaged that the reports of the ombudsman would have to go to as far as the courts, really. Yes.
All right, maybe let me ask it differently. Of the three arms of government, who should protect the public protector?
The reason why we say the office of the ombudsman should be accountable to Parliament is because through the system of checks and balances of the separation of powers, you want to ensure that the ombudsman reports to a body which it does not investigate. And that is the protection that is accorded to the ombudsman.
So which of the three should protect the public?
The legislature.
Thank you. And if you put it crudely, the legislature should protect the public protector from who? Who is, or maybe let me ask it differently. Which of the three arms is most likely to pose a threat to the public protector?
Because the ombudsman investigates the executive, so the executive is the branch that is most likely to erect these barriers to the work of the ombudsman to ensure that the ombudsman does not work effectively. But I must state here again that the judiciary also offers a protection in that it gives the office of the ombudsman the powers to make all the orders of a which are equivalent to a high court during the course of investigations. So these two protections work very well. And that at the end of the day, the report doesn't lay hidden in somebody's desk. It has to go to the legislature to ensure that it is it gets compliance from the executive.
Yes, thank you. So if we then summarize it, you're saying the executive is most likely to pose a threat, correct?
Yes.
And the primary protection should come from the legislature.
Yes.
Correct? But also the judiciary should also play a part in the protection.
Because it gives the powers.
Yes.
It gives the powers to the ombudsman.
Yes. Now, what happens in a situation? Okay, our favorite country somewhere in some continent. What happens in a situation where now you have a situation where the legislature, that is supposed to be the protector of the public protector, and the judiciary, that's also supposed to be the protector. Or let me put it this way. The legislature actually takes judgments from the judiciary and says, these are binding. We're just going to plonk them. Sorry, that's probably Afrikaans. We're just going to transplant them and you're gone. In other words, the two arms that are supposed to protect you, then wittingly or unwittingly collaborate to the one just borrows from the other some ready-made product and is the conduit pipe, and then you must be removed. Is that country complying with what should be happening?
The legislature, in this case, in the way that the classical ombudsman operates, the legislature is supposed to only come in to scrutinize the ombudsman in an instance, as I said, where there is, gross misconduct, but in the constitutional performance of the office of the ombudsman, I think the aspect of upholding the constitution comes in my view, because the office of the ombudsman is accountable to Parliament and lays its reports before Parliament. And it is at that point that they can comment and say to the ombudsman, we do not agree with this report, because they can refuse to implement the report. They can refuse to implement the report. But for when I assume, like even in my jurisdiction, I'll give an example of my jurisdiction. When a matter comes before my office and I issue a report, it is a binding, I do not issue recommendations, it's a binding report. But when it goes to the courts of law, because now it's binding, I don't even need the legislature to enforce that matter. So when the respondent appeals, if I make a finding against the respondent can go to a court of law. And when it goes to the court of law, if it goes against me, I don't think that, because that is it's the normal process. You are trying to exhaust the administrative channels of appeal. The respondent is trying to exhaust the administrative channels of appeal. And I don't see the reason why that judgment should go back to the legislature.
Yes, okay.
The respondent is allowed, it is his right to exhaust the channels of appeal, to go through the court process and go through the channels of appeal.
Yes, okay, let me ask it more directly. Is a country that allows a system where a product from the one arm of the state, the judiciary, is simply transplanted into Parliament and used to remove an ombudsman, a good system?
I would say that the checks and balances then are not working properly, because if a matter goes to court and a judgment is made, what is the reason to reinforce it again? I don't know. Maybe I don't understand the question, but as far as I can see, the normal checks and balances of the three arms of government should not cross over unless, I don't know. I'm not privy to maybe the legislation
Okay.
and the.
All right, let's cut, let me stop talking about some country somewhere else. Okay, here in this inquiry, and I may be wrong about the numbers, 90% of the charges are directly based on court judgments, which are brought here. And we were told on the first day when we got here that those court judgments are binding. And so I don't even know why we're here, because if they're binding, then I suppose we should have just wielded the X on day one here. But that's a separate issue. I'm saying that, is it a good thing that a public protector or an ombudsman can be removed on the basis of 90% of the material or more, that might even be underestimated, that comes directly from the judiciary into an inquiry, and then it's just tick box. Okay, the judge said you did this wrongly, therefore you did it wrongly. The judge said you did not give this one a hearing, therefore you didn't give them a hearing. The judge said you were biased, therefore you're biased. Off you go, chop the head. Is that what was envisaged in the instruments that you've described?
The ombudsman, by the very nature of their work, the fact that they investigate the executive, when a matter goes to court and the matter goes against the ombudsman, I think it is the system is cleansing itself well, because the reports of the ombudsman are being put up to scrutiny.
Correct.
By the courts of law. And the courts of law are able to say, no, here, ombudsman, you were wrong. And it is also a way of ensuring excellence in the work of the ombudsman. So there is no reason why, when the courts do their job, they've done their job. They've said, ombudsman, here you were wrong, or ombudsman, here you were right. They've done their job. The system has cleansed itself. I don't know. I don't see the reason why it should be taken up by another arm of government again. I don't know. That is my view. That is my professional view. That there is no need for, the system has cleansed itself. And if that ombudsman is an ombudsman who is aware of the principles and ethics of their job, they will take note of what the courts are saying. Good. And implement it in their work to ensure that it doesn't happen again.
Yes, good. So okay.
Maybe Advocate Mbofu, if we can pause. Unless you want to throw a small question.
Just give me one question, okay, just to wrap up that point so that we don't forget it. Yes, okay, let me go back to my old system. You have two countries. In one country, what you have just described happens. The judges make their judgment, and as you correctly say, it should be a learning tool for any public protector. Once a judgment says this and so on, and assume it has gone all the way up to the highest court, so it can be changed. So it's now becomes a learning document. So that's what happens in one country, and it ends there. In the other country, it doesn't end there. That judgment is taken and used by the legislature know-how to now do more than what the courts have done, to actually remove the person. Which of those two systems is better? The one where it's used as a learning, it goes its full course and it's a learning process. And as you say, hopefully it doesn't happen again. Or the one where it's taken as a weapon of mass destruction.
I think I'll just state that this is the reason why the international ombudsman world has insisted on ombuds standards. If we are to apply the standards when we are setting up, from the time we are setting up ombudsman institutions, if we say, okay, it's a pity that like, for example, all the standards have come way after ombudsman institutions have been established, but still there is a way of correcting our constitutions. There is a way of correcting our legislations. If we adhere to the standards, then such a situation should not arise.
Thank you. Thank you, Chair. We can have a break. Thank you.
Thank you, Advocate Mpofu and Advocate Sokoni. We'll pause for 15 minutes break and be back at 1:45. Thank you.
Thank you, Chair.
We resume. Ms. Sokoni, are you settled? Are you comfortable? Thank you. Welcome back, colleagues. Over to you, Advocate Mpofu.
Thank you, Chair. Good morning again, Honorable. Good. Okay, I'm just greeting you so that I can see if the tone can you either get closer to the mic or speak more loudly. All right, we were dealing with this thing, and it's in my view, a very important part of this context that we're trying to paint here. Now, I'm going back to this issue of the judgments versus the inquiry, removal inquiry.
Sorry, Advocate Paul, can you tell me where in your statement we're at the moment?
Oh, okay. In where it deals with separation of powers. Hold on. Okay, well, this issue of separation of powers is everywhere. You talk about, sorry, let me just. Okay, for example, paragraph 7. Remember, we're still talking about your favorite word, which is the protection. Okay, I'll just read it out. It's long, but since I've been asked to, I'll do it. You say that at paragraph 7, it's of the statement, which is, sorry, my pages are not.
I think page, oh, sorry, what a different page number.
I'm looking for the big number, the typed, it's 216, starts at 216, paragraph 7. Yeah, everything is important. Okay, that's 219. So, okay, good, we're there. All right. It's long, as I said, but I will. It says concerning an ombudsman's mandate, the Venice principles include, and we'll go to these Venice principles in more detail. I was just dealing with the protection thing. Include the prevention and correction of maladministration and the protection and promotion of human rights and fundamental freedom. The Venice principles stress that the protection and promotion of human rights and fundamental freedom should also be extended to the ombudsman and deputies and their staff. Okay, so let's pause there. Am I correct that the word protection, which is used twice, is used in two different contexts? One is the protection of the public. That's why it's called a public protector. But you are saying that the principle talk about the protection of the public protector herself or himself, correct?
Yes.
Which is what we're busy with here. So that's the first issue. And then they stress on the aspect of immunity of the ombudsman and the staff from court action with regard to the implementation of the core function of the institution. That's the judiciary, the thing that you and I have been discussing.
Yes, that's correct.
Right. And then it says the Venice principles refer to this as functional immunity. This is a big one we will be discussing later, functional immunity. So you can park that. States are further urged to refrain from taking any action aiming at or resulting in the suppression of the ombudsman institution. That's what I was leading you on now. States, including South Africa, have as a matter of practice included the immunity from court action of the ombudsman and their staff, right? Then you say the rationale for including this clause is meant to discourage governments from using more than one branch of government from exercising administrative or disciplinary control over the office of over the ombudsman. Disciplinary control would include an inquiry such as the one we're having here, correct?
Correct.
Says, yeah, the ombudsman rides on drawing authority from the three arms of government in order to carry out its functions. Your evidence about separation of powers, right? However, all three arms of government cannot exercise administrative authority over the office of the ombudsman. It is because the executive is so powerful, the point you made earlier, that checks and balances of the separation of powers become necessary. The very nature of its work demands that the executive be reined in by the judiciary through the judicial review of administrative power and by the legislature, which carries a watching brief of executive should be over executive actions and decisions by subjecting the actions and decisions to review through parliamentary debates and approval or disapproval in the implementation of pertinent government policies tabled in the form of bills before the House. However, the ombudsman is normally established as a corporate soul, a single person, set up a legal entity with no powers which can be equated to the executive. And here's the punchline. The office of the ombudsman was not intended to be the object of disciplinary or administrative censure by all three branches of government. This weakens the independence of the office. Is that what we're discussing now? The issue of if she or he is in a way the object of disciplinary censure by all the three arms. We've spoken about the powers of the executive to suspend. I'm now busy with what I call the collaboration, for lack of a better word, between the judiciary and the legislature for a process such as this one. Are we together?
Yes.
Yeah, thank you. So that's the answer to my learned colleague. Yeah. Okay, let's come back then to the subject. Maybe thanks to her, we should then use this paragraph as the basis of how we take this further. Yeah. Now, I'm saying then, if you have a situation then where the executive, in this context, we know the bad guys, they're likely to be the ones who are tempted to threaten the public protector with reprisals. I think we've established that. I'm now looking at the other two arms. I'm saying if we have a situation where the two arms are in a way just passing the same judgment that came from one of the arms called the judiciary is now being used by the legislature. So in a way, you have all the three arms, as it were, ganging up, for lack of a better word, against just this one institution. Who then must protect the public protector?
The office of the ombudsman, as I stated, is established as a corporate soul. And the office is accountable to Parliament. So any issues which arise in the office should be tabled before Parliament. Any sort of whether it's administrative, whether it's a legal matter which they are facing, should the public protector or the ombudsman should feel free to go to the legislature and seek counsel, you know, for that particular matter or seek protection for that particular matter. Now, with respect to the judiciary also offers protection to the ombudsman in that when the reports are tabled before the judiciary, the judiciary gives that extra scrutiny, that independent scrutiny also on the reports of the ombudsman. So these protections can operate and should operate independently of each other. However, when one arm of government takes a decision, perhaps that is not advantageous to the ombudsman, I don't know, because I have not seen this happen before. I don't know how it crosses over. So one is administrative, one is an administrative disciplinary procedure. Then, but it's emanating from a finding of the judiciary. I think it is not supposed to be so, because when the judiciary makes a finding over a report, that is the normal procedure. Like I said, that is the normal cleansing system.
All right.
The system is cleansing itself out. And the public protector, like I said, I repeat again, the public protector or the ombudsman learns a thing or two and changes the procedures, the processes within the office to adhere to the judgment.
Yeah.
And I think that is what happened, for example, in the Zambian situation. There was a matter which went against us, where the respondent took us to courts. And we changed our processes and procedures accordingly, because the constitutional courts also gave a ruling in that matter. And we accordingly applied their guidance.
Yeah. Okay.
So I would not expect that matter would cross over again to the legislature.
Yeah, well, it happens here in South Africa. All right. And let me just be clear that when I say maybe so that your evidence is not misunderstood, I'm talking about, shall we call it, institutional and structural independence and protection mechanisms. When I say the legislature and the judiciary, I don't mean like one day in some dark room, you have the Chief Justice and the President and the Speaker of Parliament saying, oh, let's go and get the public protector. I'm talking about institutionally entrenched independence and the dangers of the absence thereof. So that's why I was asking you whether a system that allows for a product of one of the arms, being the judiciary, to simply be used by the other is a good one or a bad one. But that's fine. Let's take it further, because I think you have given the answer. Now, what I'm coming at is this, really. Let's just cut to the chase. Here, again, I want to give to my so-called exemplary country. In this country, here, in this room, actually, when the issue of, for example, the suspension, the unlawful suspension of the public protector is raised or was raised to the people that you say should be protecting her, the answer is that has nothing to do with us. That's the stance of the South African Parliament, that the issue of the suspension, lawful or unlawful, retaliatory or not, inspired by 31 questions or not, has got nothing to do with us. Pontius Pilate approach. So South African Parliament has washed its hands in biblical terms from such a thing, such an intervention by the executive. Is that how the system is supposed to work?
You have said in your previous question that I think 90% of the charges are emanating from court judgments.
Yes.
So if that is the case, the precedent has already been set. And if there is another court judgment that comes out and that favors the office of the ombudsman, then it's taking into account procedural fairness, then that judgment must also be taken into account by the body that is looking into the matter. I think it's just fair. It's only fair that if some judgments have been tabled before a body that is hearing a matter, and those are adverse to the person, and then some other judgments that are in the favor of that person come out, and those are not accorded the same and equal attention by that body that is hearing the matter, then there's been some unfairness, and this involves the issue of a person's rights.
Yes. Thank you. So then your answer to my question, which is whether it is correct, fair, in accordance with the principles that you have enunciated here, for a parliament of a country to say the matter of the fairness or unfairness or legality or illegality of a suspension of the public protector has got nothing to do with us. Is that consistent with those principles?
No,
If that is
doesn't
the-
seem to be
sorry.
consistent. As I have said, if they are taking into account consideration of certain judgments which have come out, which are disadvantageous to the person who is appearing before them, and then they take those into account. Then there are other judgments which come out which are advantageous to that person, and then they say that they cannot take those into account as well.
Yeah.
Then the issue now of fairness comes in, because the rights of that person have not been respected.
Yes. Okay. That's probably the worst case scenario. Let's even be kinder. Let's assume this is another country. There's no situation where they've taken into account the judgments that are not favorable and what have you. We're just starting from scratch. And you come to that country, you say, Parliament, my protectors, please, I have been illegally suspended. And the parliament of that country says, this has nothing to do with us. Forget the comparison and so on. Is that on its own a good thing? It's like going to a police station and the police say, you say, someone has just stabbed me, and they say, well, it's got nothing to do with us. The body that's supposed to protect you, if it says an illegality that has happened to you has got nothing to do with them, is that in accordance with the principles?
I think before a person has been suspended, they must be made aware of the charges that are against them, and they must be given a fair hearing. So this is a body of ultimate justice, and fair play. And as a legislature, and it should be able to assist an officer who is accountable to them to say, well, what are the charges before you? Has fair play been taken into account in this particular instance? And they should accord the appropriate protections. If they are available, they should accord those protections.
Let me then go to page 414, please.
Are you there? Slow tempo.
Where do you want to go?
It's a-
Advocate Mpofu?
414, oh, I thought they're all on item H. Are we not on item H today? Okay, so I'm just giving you the page numbers like I've done before.
Advocate Mpofu, for these different items that your
Thank you.
teams put into bundle
That's
H,
the one.
and they're not marked 414. So we have
The
difficult,
page, but the page numbers are continuous.
so it's a
Anyway,
page number you.
we found it. Yeah, thank you very much. Let's go to paragraph 157. Let's go down. Yeah, I'll read out. This is what our court has said in this situation that this parliament says has got nothing to do with them. It says, in our view, this is a full court, the hurried nature of the suspension of the applicant in the circumstances, notwithstanding that a judgment of the full court was looming on the same subject matter, leads this court to an ineluctable conclusion that the suspension may have been retaliatory. That's the reprisals you are talking about, and hence unlawful. It was certainly tainted by bias of a disqualifying kind and perhaps improper motive. In our view, the president could not bring an unbiased mind to bear as he was conflicted when he suspended the applicant. I'm saying that situation, if it happens in any country, can the legislature of that country say, we hear this, but it has nothing to do with us? Is that a good thing? Or rather, maybe let's not use good or bad. Would that situation, the behavior of that parliament, be consistent with the principles that you have enunciated from the UN, the IOI, IOMA, or ARTABO principles and what have you, all the protections you have spoken about? Would an attitude of a legislature that says this about its ombudsman, when a court has said this, be consistent with those principles?
It would not be consistent with those principles because this is a person's rights that we are talking about. And that person is a citizen of that country and entitled to enjoy the rights that can be availed to by the body that is carrying out the investigation. So,
okay.
No.
Thank you very much. All right. So, and well, let's not even go to that parliament of that country refusing or saying that that person who's accused of all those things there is not a relevant witness to be called. I think the answer to that follows from your previous answer, but that's a debate for another day. All right. Now, let's go back to I'm just wanting to check if my country is not going to be expelled. All right, so far we've found big areas where the first one was the ability of a member of the executive who's being investigated in our case on 6 different investigations to suspend the person investigating them without having to check with Parliament or anything like that. And the second one was this issue of the Parliament that says mea culpa. we're not going to get involved in whatever abuse has been found by the court. All right. Now, if you go to the OR Tambo Declaration, and I'll take you just quickly to the minimum standards on page 268. Thank you. 268. The two words that seem to permeate all these instruments are captured at 1.1. The independence and autonomy of these institutions must be guaranteed by the Constitution. Agree?
Yes.
Okay. Now, independence, I think you've spoken a lot about. We'll come back to it in a different context. I want to now talk about autonomy. Just again to see if the South African situation conforms with the international instruments. By the way, South Africa is a signatory or a member of the UNGA, United Nations General Assembly instruments, which will come into. And so is your country, correct?
Yes.
Yeah. All right. And as we've seen, it's a signatory to this document, and it even houses the institute, AWOC, correct?
Yes, that is correct.
Right. Now, what is this autonomy that appears in all these documents, whether it's the Venice principles, the Paris principles, the OR Tambo, the UN General Assembly? Why is this important? And I said we'll come back to the issue of functional autonomy. Firstly, what is that? And why is it important?
The Venice principles refer to functional autonomy of the ombudsman, meaning that the ombudsman must not be brought up for charges concerning his constitutional, legislative, or administrative functions. And the reason why this is recognized as a need to extend the protection to the ombudsman in that for the administrative functions of the ombudsman, if, for example, the members of staff are employed by the executive directly, it is likely that they can be compromised. Or for example, some of the standards go as far as saying the ombudsman must not be housed in a government building with other government institutions, because it means that if there are complainants coming from those government departments, they'll be apprehensive to come and lodge a complaint. So when we talk about administrative autonomy, we talk about the staffing, the administrative support to the institution. As much as possible, this should be independent from the executive. Then when we talk about the legislative autonomy, we're talking about the setup within the Constitution and the enabling statute, which has provisions which talk about the independence of the institution, that the office holder shall not be accountable to any other office, and no answerable to any other office. And also that in the investigations that are carried out by that particular office, there shall not be any interference by any arm of government from any person. So this is what the Venice principles refer to as the functional autonomy. And they even go further to say that the office holder must have immunity from any form of civil or criminal litigation regarding the administration of the mandate of that office. And this is, like I said, this is a recurring theme in all the instruments that with regard to the office of the Ombudsman.
All right. Thank you so much. All right, we'll go to the Venice principles themselves. For now, I'm just testing it against, they say charity begins at home. So I'm just testing it against the OR Tambo principles. All right, so let's go now to our favorite country, which, as by now it must be clear, is South Africa.
Was that the country in the air?
Yes, it has come back to earth. Thank you. Now, in terms of functional autonomy, again, I'll describe your situation, true story. And you'll tell me if it is consistent with functional autonomy. We have an impeachment process and inquiry, parliamentary inquiry at that. Okay, it's the high level, highest accountability mechanism. In that inquiry, you have 18 witnesses that are called. 15 of those are employees, including disgruntled employees who have this and that gripe and were given this letter or that letter and what have you, or disciplined for sexual harassment and everything like that. Is it consistent with functional autonomy and immunity that Parliament should busy itself with those kinds of internal workings? This one came late to work and this one was disciplined. Maybe they should not have been disciplined and what have you. Is that consistent with the principle of the sacrosanct principle of functional autonomy? Let's exaggerate. Let's say there were 15 witnesses and all of them were about that.
I would say it is not consistent with the principle of functional autonomy because the institution of the Ombudsman, by its very nature, as I said before, is a creature of the executive. And I don't know how the system is here in South Africa, but most, like for my staff in my office, all of them are civil servants. So if they were all to testify against me, it would really be flying against all the principles in the book regarding the functional autonomy of the Ombudsman. And that is why I think all the principles, all the international instruments insist that the members of staff of the ombudsman should be employed directly by the ombudsman.
Yes. And in line with what you and I will know as the principle of reciprocity in matters of that kind, in layman's language, the public protector should therefore have the right to hire and fire autonomously. Correct?
Yes, according to the standards, yeah, the ombudsman should have that right in order to prevent these issues of conflict of interest arising even from among the members of staff.
Yes. And then would a parliament, a reasonable parliament, if there's such a thing, busy itself then with, no, this one, there was an interview and then number 3 should have been number 2 and this one was hired instead of that one, or vice versa. There was a disciplinary process and this one got an Audi letter, this one didn't get it, that kind of thing, which has to do with hiring and firing. If a parliament busied itself mainly, 90% of its business was around those issues, would that be consistent with functional independence and autonomy and immunity?
Well, speaking from, like I said, from my own jurisdiction, first of all of them are civil servants. So I would take it that any tribunal that is calling them up would first try to establish the relative independence of these particular witnesses. Yeah, and then secondly, I would say that each of these people, if they have a grudge against the office of the ombudsman, they have the right to go to any court of law or any tribunal to bring up their cases and complain. I don't see the reason why it would have to go through the one institution which the office of the ombudsman is accountable to.
Yes.
It seems a bit, I don't know, odd anyway.
Well, that's an understatement, but we can understand you should be diplomatic as our visitor. But I think when we do the wrapping up, we'll find other adjectives than odd. But yeah, be that as it may, you were fortunate or unfortunate to be here for the evidence of Mr. Samuel, for example. That's the kind of thing I'm talking about. I'm saying if you had people who, it turns out, sometimes by their own admission, those who were honest enough, that they had a gripe. And as you say, like, let's assume the gripe is legitimate for some reason or another. Let's say maybe their disciplinary process was rushed or whatever. But they have a gripe at the human resources level, such as Mr. Samuel, whose evidence you listened to. The point I'm making is that for that to be entertained, and as you've said, it could be entertained in the labor court or whatever, we have such a thing in this country. But for those people who have those gripes, is the platform of a disciplinary or a removal process of an independent function by a parliament, the platform to entertain those kinds of things. I'm not saying they should be suppressed, as I think you've said they've got other avenues, but should they be expressed in the context of a removal process vis-a-vis functional autonomy?
You see, these matters of hiring and firing and disciplining, they are going on almost every day in almost all institutions. So are we, I think Parliament's time would actually, they would be overwhelmed with such matters if indeed all the institutions that are accountable to Parliament, if they were to go through a similar process, they would actually, that's my view anyway. I think, to put it simply, it would really be an overwhelming process for them if that is the way that we have to go, because in each and every institution, there are issues of staff turnover, if I can put it that way. So if we really were to go into each and every institution, we would actually find that there are people who have issues with their supervising officers or heads of institutions. So that is the reason why I'm saying that if a matter has to come regarding the public protector, has to come before any body or any tribunal, it should be a matter where there is really gross misconduct on the part of the ombudsman, not just the day-to-day running of the office and the day-to-day disciplining of officers. I think I recall, for me, in my office, there was a time when there was a non-implementation of decisions by the CEO, and I did, this person was coming from the government, and I did explain to the government that there is non-implementations of the decisions of both the head of finance, the secretary of the treasury, and the secretary to the cabinet, and myself by this officer, and I surrendered that officer back to government. I don't know if that would.
Yeah, well,
Obviously, I mean, I'm just trying to give an example that these things happen.
yeah.
They happen all the time.
No, that's a good example. As I say again, you are diplomatic. When you say you surrendered the person back to government, you mean you fired them? That you got rid of them from your office.
From the institution, but
Yeah. All right, thanks. All right, no, fair enough. And you were not impeached. You are still here.
No.
Yeah. All right. Now, again, let me just get zero in. You know, I say that we are a young democracy, and maybe hopefully we'll learn something from this process. We've been talking about the duty to protect, and you used that word repeatedly this morning. So let me take it closer to home. The drafters of our constitution were wise enough to think that a day like this might come, and the elevated status of the legislature in particular as now one of the organs, not just the organs of government, but also as an organ of state. The obligations actually to protect the public protector were codified as follows in section 181, 3 and 4, but let me start with 181.3. Then I'll ask you to comment on the examples that I'm giving. 183 says these institutions, and that includes, let's say, the public protector, are independent. I'm sorry, Chair, I'm reading from 181.2 of the Constitution, of our Constitution. These institutions are independent and subject only to the Constitution and the law. And they must, underline must, be impartial and must exercise their powers and perform their functions without fear, favor, or prejudice. Starting there, okay? We've dealt with the issue of fear. The fear, we know where it mainly would come from, okay? Now go to the 3, subsection 3. Other organs of state, in other words, other fellow organs of state in general, but I'm talking now specifically about Parliament, which has an elevated status, through legislative and other measures, must assist and protect these institutions to ensure the independence, impartiality, dignity, and effectiveness of these institutions. So read it now specifically to our context. The Parliament and other organs of state, through legislation and other means, must assist and protect the public protector to ensure her independence, impartial, dignity, and effectiveness. Okay. And then the last one, the next one, which captures probably the sentiment you've just spoken about functional autonomy even better. So no person or organ of state may interfere with the functioning of these institutions. Would you agree that that sentiment captures what you and I have been calling functional autonomy?
Yes, I would agree. I would actually even further state that as democratic states and also having a system where we lay precedents, we must always examine the processes and procedures that we implement regarding the protection of human rights, because the precedents that we are setting in the hands of, let's say, a nation that does not have adhered to proper democratic principles, they can misuse these sorts of precedents to intimidate and harass and victimize an ombudsman, because they will say, well, it has been done before, so we can do it again. They can replicate it. So yeah, we have to be very, very careful when we are dealing with the implementation of human rights issues. We really, really have to be so careful.
Yes, I agree. But specifically talking about the institution of ombudsman, I'm saying that our discussion so far, with the examples that I've given you, let's start with the duty to protect. I think we dealt with that in the morning, and I've given you examples which you have agreed are inconsistent with the protection of the independence of the institutions. But now we're talking specifically about functional autonomy.
Yes.
And I'm saying to you that, the word is there. Okay, maybe let me do it like this. Why do you think our founding mothers and fathers of our Constitution found it necessary to include that subsection 4, which you and I have agreed deals with functional economy? No person or organ of state may interfere with the functioning of these institutions. And you've said that includes the HR hiring and firing issues. Why? What's the importance of that in the context of the ombudsman principles that you have described?
I think let me put it like this. the functions of the Office of the Ombudsman depend so much on its independence. There is no way that the Office of the Ombudsman can function without administrative and legislative autonomy. That is a core principle. It can't.
And if it is undermined, if there is a process that undermines that, is that in accordance with or in conflict with the accepted principles of this office, including 1.1 of the OR Tambo declaration?
Yes, it obviously breaches all the international instruments because they all talk about this functional autonomy, and it doesn't make the next incumbent of the office feel any safer. I think to have a process like this going on.
That's okay. That's no, all right. In other words, if a public protector or a judge, and I'll come to that, was to be impeached on in breach of the principle of functional autonomy, the next one will know that you can't fire anyone, you can't give anyone deadlines, you can't do performance management, because one day these people might go to parliament and you'll be impeached. Is that what you're saying?
Yes, you make the ombudsman literally a slave of the system. Yeah, because they'll be so frightened of their own shadow.
Yes. Yes. Well, it's more than looking over your shoulder to, or chasing your shadow. I think it's a clear warning that you must refrain from doing so. Isn't it that when we do disciplinary measures, we are teaching a lesson even to those who might follow?
This is the reason why I talked about the issue of precedent. But maybe I must state that these things are real. This is the reason why these issues have been put in these documents. I also went through a similar process in my early years when I was appointed as ombudsman. When every single process that was going on in the office was under the telescope of law enforcement institutions. So it really disturbed the functioning of the office, and as I said, it strengthened my resolve to have the office be transformed to a legislative ombudsman. This was being done by the executive at the time. Yes.
Thank you. And one has to assume, and I'm sure you know this, I'll ask it as a leading question, that when your country, Zambia, migrated from the executive ombud system to the current parliamentary system in 2016, these were some of the issues that were being thrown away into the dustbin of history to move forward.
Yes, yes.
And
we are still even going through the process of implementing the administrative autonomy.
Yes. Now, in that context, therefore, a country that then goes to that dustbin and fetches the system where administrative and functional autonomy is subjected to parliamentary scrutiny. Is that a movement forward or a movement backward?
For the functional autonomy, especially, I think it's a movement backwards.
Thanks. All right. And by the way, let me just say this. Okay, so sorry, I don't want to lose this point, but just to link up something to do with your credentials, which is relevant to this. We all accept that one of the one of the most well-known protections for these kinds of offices is something called security of tenure, correct?
Yes, yes.
And you've spoken about immunity, we'll come back to that. But the security of tenure, I'm asking you out of interest because in one of the instruments, and we'll go to them, it says that the term of office should be basically as, well, firstly, it must be longer than the term of office of the parliamentarians. And it must be possibly as long and secure as possible. I think in your country, you say next year you'll be in the office for 20 years.
Yes.
And in Zambia, you can hold the office until you are 60.
Yes, until the age of 60.
Yeah. So if you are employed at age of 20, you can hold it for 40 years.
Yes.
Theoretically.
Yes, yes.
Thanks. All right. Now, and that's part of the protective mechanisms from this kind of thing, from interference by all sorts of people who are conflicted, correct?
Yes, but it's not the prescribed model.
Mhm.
The prescribed model is that the tenure of the ombudsman should be for a prescribed time, maybe 2 terms of 5 years, or like here in South Africa, 1 term of 7 years. And this is to ensure that the term of office is certain and it should not be interfered with. It's usually prescribed by the Constitution. And one of the reasons why there is security of tenure for the office is to prevent the unlawful or unwanted removal of an office holder from office before they have finished their term of office due to other reasons which may not be known to other parties.
Yes. Thank you. Okay. And no, the point I was really driving at is that the general trend is to lengthen the period.
Yes.
And we in South Africa are probably at the barest minimum, because according to the Venice principles, the minimum period should be 7 years. But obviously the word minimum means it should preferably be more, but not less than 7 years.
Yes.
And Chair, I'm just digressing to get rid of this. I'm still going to go back to what I was busy with. But since we're here, can we go to page 321? Start at 318, sorry. Okay, is that a copy of the so-called Venice principles?
Yes.
And why are they called Venice principles?
They are called the Venice principles because they were drafted by the Venice Commission of the European Commission.
Okay.
Yes.
And it would be fair to say that these principles have now gained recognition worldwide via the instrument of the United Nations.
Yes. Actually, the background to the evolution of the Venice principles is that initially, the Paris principles were adopted
Mhm.
by the United Nations as an instrument to help establish national human rights institutions throughout the world and to also protect these institutions. So the Office of the Ombudsman was also included as a national human rights institution. But later on, it was thought that really the Office of the Ombudsman is not like national human rights institutions, because national human rights institutions receive complaints of human rights from any member of the public against any person or anybody that has infringed their rights. But for the Office of the Ombudsman is unique because it investigates the executive. So it was thought that it needs its own unique set of principles to protect the work of the Ombudsman, and hence the issue of the Venice principles. But they were sent out to various regional bodies, ombudsman bodies throughout the world to get input from everyone internationally.
Yes, okay, thank you. Chairperson, if you forgive me, I think instead of, I just wanted to isolate one thing from the Venice principles, but I'd rather deal with them. I mean, obviously that introduction we won't repeat, but if I can just move back to, so that we don't lose there's just one point I wanted to wrap up on the other topic we were busy with. And the security of tenure thing was just an example, but so I don't want to follow that now. So thank you for telling us where the Venice principles came from. But I want to point out, to go back to this issue of independence and autonomy, the importance thereof in South Africa, which is, I think people just don't get. You have, in your earlier testimony, said that in some countries, and including this country, I think, the public protector is one of the qualifications in the legislation is that they must, both in terms of salary and status and qualifications and so on, is regarded in the same level as a judge.
Yes, that is correct.
Yes. And that is also not a coincidence. I mean, it's not, we could say is regarded as a chief of police, or we could use all sorts of examples. The fact that a judge is used as the reference point is not a coincidence. It's because these are both independent institutions, correct?
Yes.
And well, in your case, you were even, the chair called it a promotion, but that's debatable, whether it's a promotion or a demotion. But you were recently asked to serve as a judge.
Yes.
Right. And if, okay, well, firstly, maybe just to make sure that the chair is not worried about what will happen to him when he gets to Zambia. Can we allay his fears that you have you decided to accept that position or not?
There were discussions back home, and it was pointed out that the Office of Ombudsman has got security of tenure, and it was much better actually to allow the office holder to complete the term of office before being considered for any other office. So happily, the government acceded to that submission, and therefore I'm still the Ombudsman of Zambia.
So you escaped from the quote unquote promotion for now.
Well, I suppose so.
All right. All right, the point I really want to get to is a more serious one about what I say in South Africa. Unfortunately, there's I don't know what to call it, a dire failure to appreciate this issue. It's about the independence of the Office of the Public Protector, in particular, vis-a-vis the independence of the judiciary.
Yes.
Our constitution is not confused about this. It's just human beings. It's actually uncanny. If you look at section 165 of our constitution, if I read this thing as for so many, since it was produced, but this just one of these days occurred to me. Shows you that you learn every day. If you look at section 165(3) of our constitution, and 165(4). It's a pity, I don't know, Ketsepo is our IT whiz kid. If she can put the two together on two different screens. Okay, she's not that much of a whiz kid, it turns out. But it's fine, we'll have a mental picture because we read the other one earlier. But for the sake of emphasis, Chair, if you allow me, I'm just going to read this out. You'll see that this is almost, it's a carbon copy of what I read to you earlier of section 182, literal. This is what, it's just that the other one, this time the other one comes first and so on.
Yes.
So the first one is about functional autonomy that this is now in relation to the judiciary. No person or organ of state may interfere with the functioning of the courts.
Yes.
You remember we said earlier, 181.4, sorry. No person or organ of state may interfere with the functioning of these institutions. Literally word for word.
Yes.
So the constitutional founders found it necessary to use the exact same words for the protection of the public protector in this case and a judge.
Yes.
Okay, then the next one, 165.4. Again, literally a carbon copy. And I don't think this was a result of laziness or of drafting. I think it was deliberate. It was sending a message to us, which we have not internalized. It says, organs of state through legislative and other means must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. You see, 182.3 is exactly the same, except that where it says the courts, it says here, these institutions.
Yes.
Yeah. Now, if the founders of the Constitution thought that these two institutions should be protected in almost an identical way, then why is it that there should be a difference when it comes to the actual protections? And I'm coming to something you said earlier. Remember my example about the two countries and what have you.
Yes.
As far as the judiciary is concerned, you said that if the legislature has to get involved, it must be involved at the end of the process.
Yes.
And rather, if the suspension, we were talking about the suspension by the president, it should rather come at the end of that process.
Yes.
Yeah. Now here in South Africa, this is what we're told. When it is a judge, this is common cause, you can take it from me, because I used to be involved in it. When it is a judge, you have an inquiry, much like this one. Okay.
Recording stop.
And-
Recording in progress.
Okay. And only until the person has been found guilty at the inquiry may the president suspend. That's a good
Yes.
thing. Okay.
Yes,
But here it is believed that in this case, the president may suspend before the finding of guilty, as it has happened to the person sitting here next to my right. Now, if we have this principle of, as I say, almost carbon copy protection by the Constitution, is which of the two systems is fairer? The one that's the protection given to the judge by being only subjected to suspension after, or the one where you may be suspended before any finding of guilt against you?
The proper position, as stated in the OR Tambo declaration,
Mhm.
and the recommendations in most of the international instruments, is that at minimum, the office of the ombudsman must be equated to that of a judge.
Mhm.
Now, what do they mean when they say it must be equated to that of a judge? It means that the terms and conditions of service of that office, as well as the powers of that office, must be equated to that of a judge. And this is not being implemented because, like I said, there is this contrast between civil law jurisdictions and common law jurisdictions. And I would wish that common law jurisdictions would take that on as well, because it would just these two principles, the principle that the reports of the ombudsman must only have the effect of recommendations, and then the ombudsman's terms and conditions of service and powers must be equated to those of a judge, be it a judge of the high courts. That is the best case scenario, because first of all, the report of the public protector will not be appealable to the courts of law. One, because it's their recommendations. Two, because the public protector is equated to a judge. Yes.
Okay, thank you. All right, I can see you are eager to come to the real issue. I'm saving that for after lunch, which is the issue of whether the best system, as we all thought in South Africa, including myself, I must confess, whether the best system in reality is that which makes the outcomes, I'm trying to look for a neutral word, of the public protector binding, and conventional wisdom says that's a better system, or a system where it's just recommendations. And as I say, we'll come back to this because that's really the main thesis of your paper. But just to get it out of the way, from your analysis, is this thing that we believe, and maybe we did it because at a particular time we were after a certain individual, but is a system where the outcomes of the public protector are binding, or rather, which one of the two systems where the public protector's outcomes are binding and where their recommendations is more consistent with the notion of the independence and autonomy, safety, of the public protector?
The concept of the ombudsman is based on the principle that because recommendations are not justiciable,
Mhm.
to prevent the office of the ombudsman being subjected to unnecessary litigation and being subjected to unnecessary victimization,
Mm.
the reports of the ombudsman must have the effect of recommendations. That is the classical model. That is how it has been. It is the tried and tested model. That is how it has been from time immemorial. However, I fully understand that, of course, a lot of governments want to have the force of an enforcement mechanism given to the office of the ombudsman. But we already have law enforcement agencies in our countries. So when an ombudsman carries out an investigation, they can make recommendations that this particular matter must be transferred to the Anti-Corruption Commission. It must be transferred to the people who are in charge of money laundering. It must be transferred to this wing of government. So there are systems in place to ensure that the report of the ombudsman is taken seriously.
So which of the two systems? So yes, I know it's lunch, Secretary Chair. We have a system A where it's the binding, and another system B where there are recommendations. Which system? Okay, let me put it this way. Later on, I'll even say that we wouldn't be here if we had not had a system of binding remedial action, but that's a story for another day. But in your analysis as somebody who has experience in this field, who is an expert, who understands all the different models, and you've given us all the comparatives, just directly, is the system where the outcomes are recommendations the better system qualitatively, I mean, taking into account all those things, or the one where there are binding outcomes or remedial action?
From my own experience, the classical model where the effect of the ombudsman's reports is mere recommendations is the better model. It's the stronger model. It entrenches independence for the ombudsman.
Thank you, Chair. On that note, that was just an introduction to the topic that I was saying I was saving for after lunch, but it came out, so I thought I might as well lay the basis. Thank you, Chair.
Thank you, Advocate Mpofu. Thank you, Ms. Zulu-Sokoni. Colleagues, we will pause there for lunch and be back at 2. Thank you.
Thank you, Chair.
I hope you had a good night, lunch break. Thank you very much. We resume. And I immediately hand over to Advocate Mpofu to continue. Over to you, Advocate Mpofu.
Thank you, Chair. Good afternoon, Honorable Sokoni.
Afternoon.
Right. Okay, I asked the chair to give me the opportunity to wrap up that topic because I wanted us after lunch to come back. Sorry, more specifically to the Venice principles. And just for as a reminder, we've already established that these principles have been received and adopted directly or indirectly at continental level, at international level, and even by the UN. Correct?
That is correct.
And those principles are quite clear in their intention by the heading. It's page 318. Please.
218, slow table.
318. Yes.
318.
Yes. Excuse me. We've gone through the reason why they're called the Venice principles and all that. But I just wanted to say that from the heading, it's quite clear what they are all about. It says on the principles on the protection and promotion of the Ombudsman institution, sorry, otherwise known as the Venice principles. Let's go to 319. These were adopted in 2019. As at that point, it said the first one is noting that there are presently ombudsman institutions in more than 140 states at national, regional, or local level with different competencies. We established that. That's the constituency of Honorable Kajuju. And it says that the recognizing that these institutions have adapted into the legal and political system of the respective states, we've covered that. And then noting that the core principles of the Ombudsman institution, including, and this is where I'm coming to, independence, which we discussed before lunch, objectivity, transparency, fairness, and impartiality may be achieved through a variety of different models. So I suppose by that we are to understand that those are the core principles, but it doesn't mean every country under the sun must have the same system for as long as they respect the core principles.
Correct.
Right. Just go to the last one. Expressing serious concern with the fact that the Ombudsman institution is at times under different forms of attacks and threats, such as physical or mental coercion, legal actions, threatening immunity, suppression, reprisal, budgetary cuts, and limitation of its mandate. again, some of those issues we have not covered, such as the physical and mental coercion, although it applies here, we'll deal with it when the public protector is testifying. But I'm more interested in in what they call suppression reprisal. What does that refer to?
When they refer to suppression reprisal, they're referring to acts of reprisals against the office of the ombudsman, therefore resulting in suppressing most of the powers of the public protector and even the principles and that on which the office of the ombudsman is based on.
Right. And also very quickly, something that we have covered, please go to page 320, right at the bottom. Again, if you want to comment, you can comment, but I think we covered some of this. It says the ombudsman institution shall be given an appropriately high rank, also reflected in the remuneration of the ombudsman and in the retirement compensation. Why is that important?
Of course, what they are talking about is ensuring that the ombudsman is untouchable, cannot be corrupted. The conditions of service must be sufficiently high, especially if they're equated to that of a judge. This is the reason why we protect our judiciary. The terms and conditions of service are sufficiently high in order to discourage any official of the judiciary from being enticed to receive any sort of bribes or anything.
Right. And incidentally, why we're talking about the judiciary, bearing in mind the discussion we had this morning, which I want to revisit about what, let's call it parity of treatment. Is it in accordance with that principle? Or no, let me ask it differently. Have you ever heard of a situation where a judge, let's say, gives a completely outrageous judgment and gets scathing remarks from the appellate courts about it, which happens all the time, and then that judge is then called to parliament for impeachment just because they had a bad judgment against them? Would that be, would that be consistent with the system of protecting the independence of the judiciary?
Normally, in such a situation, the defendant, I mean, be it whether it's the plaintiff, would be in a position to appeal the judgment. There would be, I think there hasn't been any situation where the judge has to answer because his answer to any authority because his decision has been appealed against.
Yes. All right. And paragraph 10 about the minimum term of 7 years, we already went through that. Oh, no, we didn't. I'll just read it out. I don't need you to comment, you can just confirm. So the term of office shall be no longer than the mandate of the appointing body. The term of office shall preferably be limited to a single term with no option for re-election. At any rate, the ombudsman mandate shall be renewable only once. The single term shall preferably not be stipulated below 7 years. So they're saying preferably non-renewable, but if it's renewable, it must only be once. And a minimum of 7 years. We've already confirmed that.
Yes, that is correct.
Okay. And what I really want from you are the underlying principles. So it's not like somebody just woke up and said, well, these people must serve only for 7 years or they must not non-renewable. It is to serve a particular purpose. What is that apropos independence of the institution? Why is it important? What would happen if these people could have renewable terms, 6 or 7 renewable terms? How could that be a threat to their independence?
The proviso which states that the term of office should be non-renewable is to prevent any arm of government trying to negotiate with the ombudsman that, no, if you take an investigation in this particular way, then we'll give you another term of office. So there should be no reason for the ombudsman's term of office to be disturbed, and there should be no reason for the ombudsman to be enticed or to get attracted to compromising his position simply because he wants his term to be renewed.
Good. Thank you. And because isn't it human nature being what it is? If my term was renewable, then let's say it's a 7-year term. On the 6th year, am I likely to make findings against the people who are going to be considering whether I should stay or go?
Yes, exactly. That is the reason why I said that to avoid the ombudsman being compromised. This is just human nature, you know.
And doesn't it also apply to our previous example? If I know that this person has the power to suspend me, for example, willy-nilly, and if I'm a calculating public protector, then I will avoid even investigating them, or let alone to ask them 31 questions.
So the office of the ombudsman should be above reproach. It should be beyond the reach of any person.
Yeah.
This is the reason why the provisions and the protections you see in these international instruments have been couched in such a way that the office is really cemented and entrenched, you know, under all the protective principles.
Yes, principle 11, and again, I'll ask for a comment like that as to the underlying rationale, as you understand it. It says the ombudsman shall be removed from office only according to an exhaustive list of clear and reasonable conditions established by law. This shall relate solely to the essential criteria of incapacity, inability to perform the functions of office, misbehavior, or misconduct, which shall be narrowly interpreted. And I want to emphasize that last part. In other words, misconduct could be anything from, you know, stealing an apple or coming to work late or whatever. So what is the purpose? And that which says that it must be solely, it's quite restrictive. Solely relates to this and that and the other, and those must be narrowly interpreted.
Yes.
What would be wrong with interpreting them widely as in the normal course?
So interpreting any of these provisions like incapacity, inability to perform the functions of office or misbehavior, interpreting them too broadly means that you are actually encouraging people who are either shopping for the job or shopping to have an incumbent removed from office for personal reasons. It's just to discourage petty reasons being used to remove an incumbent from office.
Yeah. And would that also apply to people who have like who are campaigning for the removal of the public protector, sometimes even before she starts? We just don't like her for some reason or another. If it was not, if those terms are not narrowly interpreted, wouldn't it open her to that kind of abuse by, for example, an individual or a political party that has a vendetta?
Yes, definitely, and it has happened before on to many an ombudsman. I think myself included. So these things are real.
Yes. Hence the need for the protections.
Yes.
By the way, no, let me finish that sentence. The parliamentary majority required for removal by Parliament itself or by a court on request of Parliament shall be equal to and preferably higher than the one required for election. I think if we escape being expelled, it will be because of that one. At least there we qualify, because there were the requirement for selection is 60%, but it's 67 point whatever, 0.6, or let's say 67% for removal. So that's a good thing, right?
Yes, it's in line with the provisions
Yeah.
of the Venice.
In fact,
principles.
you may or may not know this. In our South African sense, we were helped by the Constitutional Court. The original constitution prescribed a simple majority, and the Constitutional Court, in a case known as the certification case, said no, for the public protector in particular and the Auditor General, there should be a 2/3 majority for obvious reasons, protection.
Yes, that is correct.
Okay. And then here's the big one. The procedure for removal shall be public, transparent, provided for by law, and elsewhere it also says it must be fair. That should go without saying, correct?
That is correct.
And what should happen if the procedure is found to be unfair in one way or another? I'll make an example, quote unquote example. Let's say in the process, the public protector is denied legal representation, and the procedure just continues without any legal representation. From the face of it, would that be fair?
No, it would not be fair.
All right. And again, let's make another example. Let's say that one of the people who are supposed to judge the public protector or to remove her is married to the complainant. Would that be fair?
I beg your pardon?
Let's say one of the people, let's say there's a panel of 5 or 10 people or 20 or 30, but one of them is married to the complainant. Would that be fair?
That would be completely unfair. It's a conflict of interest, which should be addressed.
Okay. Thank you. Anyway, yeah. By the way, I wanted to talk to you about was yours. It presents an interesting example, because this issue of political interference, as we're saying, is real. But it looks like some countries are able to handle it better than others. And on that scale, I would say our country is on a scale of 0 to 10 is on 0. But your country seems like it is maybe on 9. How many presidents have you gone through as a public protector and you're still sitting there?
5 presidents.
Wow. Okay. And how many political parties do they represent? Were they all from the same political party?
No, that's 3 political parties, 3 different political parties.
Yeah. Okay, well, I think I'm going to move to Zambia. Here we can't even handle the factions within the same political party. But anyway, and in those years, I'm sure you've had challenges, but nobody dared because there were changes of government or changes of political parties to think that they should bring you to something like this, let's say for some HR issues, correct?
Correct. There has been no proceedings against me.
Oh. Well, yeah, that's why your country is an older democracy than ours. Yeah.
Anyway, I must state that the institution of the Ombudsman in Zambia was established in the 1973 Constitution. So the office was opened in 1974.
Wow.
So it's quite an old office. I think there's been time for them to actually learn more about ombudsmanship.
Yeah, well, I suppose you can take a horse to the water. So we will learn if we're willing to learn. Okay. The last one on 321, the competence of the ombudsman relating to the judiciary shall be confined to ensuring procedural efficiency and administrative functioning of that system. Okay, this is another typical checks and balances mechanism, isn't it? And it's misunderstood, by the way, well, I'm sure even in other situations. People think that the public protector is prohibited from investigating the judiciary, but that's actually not true. The Constitution only says that. Sorry. I think it's sorry, Chair. Okay, I'm just trying to find the sections. Yes, it's 182.3. The public protector may not investigate court decisions, which is a different thing from saying you may not investigate the judiciary. In other words, the public protector can say, or rather, if I'm an aggrieved litigant who's lost a case or whatever, or is about to be evicted or whatever, I can't take that decision to the public protector and say this judge made a mistake. But what is the situation when it comes to administrative decisions of, let's say, the Chief Justice's office or that kind of thing?
Normally, if I take the example of Zambia, the constitutional functions of the courts are restricted to the judges. And then, of course, the administrative functions, there is usually a chief executive officer. So the judiciary may be investigated in its administrative functions, but not in its constitutional functions.
Yes.
But I will vary that a little bit to say that was the position in our previous constitution. But in the current constitution, when we have become a parliamentary ombudsman, there are specific provisions stating that the ombudsman shall not investigate either the judiciary or the legislature. So we investigate exclusively the executive. But in a lot of jurisdictions in Europe, where they have the classic ombudsman system, the ombudsperson do investigate the judiciary in its administrative functions. Some even review the decisions, but
Yes,
I don't know how they do that, but they do that.
yes, thank you. So, okay, so at least I'm happy now. So at least in that respect, we are better than Zambia.
Yes.
Okay. And in fact, an example in this country had to do with this matter, where there was some gentleman who had it on quote good authority that there was going to be a judgment against the public protector and in this matter. And then the public protector was able to, or rather to do an investigation. I mean, in the end, it was overruled by the same judiciary. But at the very least, nobody said that she could not investigate the administrative side of the judiciary. In other words, whether the judgment was leaked deliberately or not. So that's a good one. That's a tick for us, correct?
Yes, definitely.
Okay. Right. Now, if you go to 322. Says 16, the ombudsman shall have discretionary power on his or her own initiative or as a result of a complaint to investigate cases in which due regard to available administrative remedies. Ombudsman shall be entitled to request the cooperation of any individuals or organization may be able to assist his or her investigation. Ombudsman shall have a legally enforceable right to unrestricted access to all relevant documents, databases, and materials, including those which might otherwise be legally privileged or confidential. This includes the right to unhindered access to buildings, institutions, and persons, including those deprived of their liberty. Okay, in this country, I think we are 50% there, because the first part, own initiative investigations are allowed in terms of Section 6 of our Act. But there's a case which found that the public protector could not subpoena documents from SARS, for example. And it's a case that you and I will discuss later or tomorrow morning. Are you familiar with the case of public protector versus commissioner for SARS?
I think I have had occasion to read it.
Yes. Thank you. Yes, we'll deal with it in a different context. But if you care to comment on just this aspect of what you think of that case insofar as it seems to suggest that the public protector should not have access to SARS documents.
The provision in the Venice Principles and in almost any other instrument that covers the issue of the ombudsman's right to have access to documents does not give actually any exceptions.
Mm-hmm.
So I was a little bit surprised that there was a need for the matter to go as far as it did in this particular matter.
Mhm.
But I also noted that the court on appeal, it was the Constitutional Court,
Mm.
stated that there could have been other ways in which the public protector could have accessed the particular records that she wanted to access. But I merely noted that the person, the owner of those records was actually not, I think, a party to the proceedings, was not a public official.
Mm.
So there are certain rules when we are carrying out investigations. We don't go to private entities to get information or to private persons.
Mm.
It's actually supposed to be the state entity that is supposed to give us the information that we need. And in the interest of justice, it should actually not be difficult for the ombudsman to access those documents from a state entity.
Okay, thank
Should
you.
not be made difficult.
No, thank you. Okay, I argued that case, so my view is probably subjective. So I'm glad to hear that you agree with what we said there. Yes, no, that's true. The public protector wanted access to documents of a certain former president in that case. All right. Then the next point deal with, in our domestic situation, what I'll call the 31 questions that the public protector asked from the president. It says the ombudsman shall have the power to interview or demand written explanations of officials and authorities, and shall furthermore give particular attention to and protection to whistleblowers within the public sector. Goes without saying, correct?
Correct.
Next one, the ombudsman shall have the power to address individual recommendations to any bodies or institutions with the competency of the institution. Ombudsman shall have the legally enforceable right to demand that officials and authorities respond within a reasonable time set by the ombudsman. And in our example, I think she had given the president 30 days, but well, it's almost 9 months now, but and we're still waiting. But why do the principals insist, or at least prescribe, that the ombudsman should give a reasonable period? Let's say maybe 30 days was too harsh, 3 months, 6 months, but obviously not like a year or 9 months.
Basically, that is, we use the instrument, the tool that is available to us, the Dial Partem rule, that we should give all parties enough time to prepare their case before the ombudsman. So it is up to up to the ombudsman. Sometimes it will be a statutory requirement that you give a certain party 30 days. But it's up to the ombudsman's discretion to even exceed a limit, a time limit which has been set by statutes. But the most important point here is that there should be procedural fairness. You should allow each party enough time to put together their evidence before they present it to the public protector.
Good. Thank you. And the next one relates to a very important topic for this particular, the charges that the public protector faces here. Maybe I should preface it by this. You would agree as a lawyer that the Constitution, I think there's a court case, I've forgotten the name. The Constitution is just a piece of legislation. It's Act 108 of 1996, I think. So it's like any other act, except of course that it's the Constitution. It's a superior type of legislation, but it's legislation, correct?
Yes, it is legislation, not the supreme law of the land at the same time.
Yeah. Yes. In fact, yeah, it's even better to put it like that. Yeah, it's law. And It just happens to be the supreme law, just as legislation is law, the common law is law.
Exactly.
Yeah, no, I'm just saying that because maybe for you and I as lawyers, that might seem so basic, but sometimes it's not that simple. Now, one of the charges here relates to something about the public protector having proposed a constitutional amendment. And this annoyed, shall we say, big capital. In this case, it was a particular bank, and all hell broke loose. How could she even think of suggesting a constitutional amendment? Is that such sacrilege? I mean, if the public protector felt that there was something that is detrimental to the public, which is in the Constitution, advertently or inadvertently, is there anything wrong with suggesting that that should be attended to by Parliament, obviously using its own procedures?
The public protector may make a recommendation if either a rule or regulation, a law, in some way it causes maladministration. The public protector may make a recommendation. It is a recommendation which the legislature, once the report is tabled, the legislature can decide either to interact with the executive to find out whether it's possible or not, or if they want, they can reject the report. The legislature has got the right to reject the report of the public protector.
Yeah. Yeah.
But that is in a situation where it's a recommendation. I don't know.
Yeah, no, I'm asking, don't worry about any other situation. I'm just asking you whether what I've just, okay, sorry, I'm making a mistake because I have not even read it. What I'm about to read to you, I was saying I'm prefacing it. Yeah. I'm simply saying that if the public protector recommends that Parliament looks into a particular constitutional amendment. Okay, maybe let me put it this way, because that's what is being alleged here. That the public protector is prescribing to Parliament, which is to me just nonsensical there. Would it stop? Let's assume she did that. Would Parliament then have to make that amendment, or will it have to follow its own procedures? And if it doesn't meet the numbers, it doesn't meet the numbers. That's the point I'm trying to get at.
Yes, Parliament would have to follow its own procedures only if it accepts that report.
Yeah.
Once the report is tabled.
Good. In other words, if Parliament doesn't challenge it, the Parliament might also challenge it. Correct. Okay. Fair enough. Okay. Now let's go to Venice Principle number 18. It's 322. Thanks. It says, yeah, in the framework of the monitoring of the implementation at the national level, ratified international instruments relating to human rights and fundamental freedoms of the harmonization of national legislation with the instruments of the Ombudsman, or rather of instruments, the Ombudsman shall have the power to present in public recommendations to Parliament or the executive, including to amend legislation or to adopt new legislation. And I'm including the Constitution as the super legislation, but under that rubric, would then there be anything wrong for the public protector presenting recommendations for the amendment of legislation or the Constitution or the adoption of new legislation? Or let me put it this way, why does the Venice Principles, in your estimation, why do they specifically deal with that power and isolate it as a power which the public protector should have?
Because when the lawmakers have the intention to prescribe a law,
Mhm.
it is only in its practical implementation, whether you know whether that law causes justice or injustice. It may look good on paper,
Mhm.
but once it is in the hands of the people who implement the law, that is the executive, then it will come up under the scrutiny of the public protector.
Good.
And then they may have to make certain recommendations to say, in its practical implementation, this law is good or bad, just or unjust. And we feel that it should be reviewed.
Good. Right. Okay, well, we don't like that in this country. I must tell them in Venice. Okay, then the next one also deals with that same subject, but now from an attacking point of view. In other words, when there's already some unconstitutionality. So I was saying that it says, yeah, following an investigation, the ombudsman shall preferably have the power to challenge the constitutionality of laws and regulations or general administrative acts. I suppose this is the flip side of principle number 18, where that's the friendly part. That's principle 18, where the public protector would recommend an amendment of the constitution. Here, it's when she now wants to challenge particular constitutionality
of law, yes.
of an existing statute or whatever.
Yeah.
So that's, I suppose the importance is the same as what you've already described.
Yes, that is correct.
Okay. All right. Let's jump to 21 at the bottom. I'll just read out: the independent financial audit of the ombudsman budget shall take into account only the legality of financial proceedings and not the choice of priorities in the execution of the mandate. Now, this is important in relation to the functional autonomy discussion we had earlier. Why do you think Venice says that the scrutinization of the financial audit of the PP should not go into the choice of priorities? For example, whether you put money in this or don't, that's the stuff we're talking about, the operational decisions. There's something here called reckless litigation, but we'll come to that later. As to whether she allocates the budget to this or that and the other, should the budget be scrutinized by Parliament to that extent? In the context, not of the normal accounting of Parliament, but in the context of a removal in particular.
Insofar as ombudsmanship is concerned, everyone comes equal before the ombudsman. So the reason why an ombudsman may pursue a particular complaint and not pursue another complaint is the discretion of the ombudsman. So long as the reasoning and the rationale is contained in the report. So yeah, there is no need really to question the reason why a particular complaint was followed, or this complaint was not followed. So long as the complaint falls within the mandate of the public protector. And most of our clients are vulnerable people who have no money. So you may find that actually you may be spending a lot more to investigate these complaints of the vulnerable people, which are maybe far away in the nether regions of the country.
Yes.
So this is the reason why that's a particular provision is phrased in the way that it is.
Yes. I think it would be fair to say that all the instruments that we have referred to, UN, IOI, IOMA, Venice, all of them, without fail, emphasize this issue of the, let's call it budgetary independence on the one hand, and budgetary sufficiency. In other words, one of the ways in which an office of the ombudsman could be victimized is by squeezing it of resources, isn't it?
That is correct.
Right. Now, in regard to principle number 21, and I'm bringing it home here, is it fair for an institution such as Parliament, to which the public protector has appealed endlessly, to have this budgetary self-sufficiency, and for good or bad reasons, those budgetary requirements have not been met? And then, therefore, she then implements measures like performance management and all sorts of things to ensure that within the limited means that are there, she can still deliver. And then that same institution turns around and says, now we're going to remove you for your way of managing the limited resources. Isn't that an internal contradiction?
Yeah, that is an attack actually on the functional independence of the institution of the ombudsman.
Yes. Thank you. Okay, then let's go to 22, which in my view still deals with something you've already spoken about hiring and firing. It says the ombudsman institution shall have sufficient staff and appropriate structural flexibility. The institution may include one or more deputies appointed by the ombudsman. The ombudsman shall be able to recruit his or her staff. That's the hiring. And we agreed that the corollary of that is the firing. How does that measure up to this issue of internal autonomy, functional autonomy? The power to recruit and
yes,
fire.
Yes, this particular provision speaks to the administrative independence of the office of the ombudsman. It's very, very important that the staff of the ombudsman and the ombudsman himself are not compromised in any way simply because they owe allegiance to a particular organ of government.
Yes, thank you. And then the next one also deals with functional immunity. 23, or almost there, Chair. So the ombudsman, the deputies, and the decision-making staff shall be immune from legal process in respect of activities and words spoken or written carried out in their official capacity for the institution. Functional immunity. Such functional immunity shall apply also after the ombudsman and deputies of the decision-making staff leave the institution. So you can see how seriously this is taken, that it's even after the person has left, they should still enjoy that immunity. But in relation to what we were saying, people come here and say, no, the public protector said this, she said we must call her madam, and all sorts of things like that. But this document says that she should be immune from legal process in respect of activities and words spoken or written carried out in their official capacity for the institution. Now, I want to make this clear. When we say these things, it doesn't mean that there must be impunity. But what is the purpose of that immunity? What is it in aid of? To protect the public protector from this kind of interference from the functioning of her office in terms of section 182(4) of our 181(4) of our constitution, which I read out to you earlier. As I said, I ask you these things for the underlying principles. Why are they immunized functionally?
The main reason is to ensure the independence of the Office of the Ombudsman from the institution which it investigates, which is the executive. So the members of staff of the Ombudsman office may be followed up even after they have left work to come and maybe testify against an ombudsman who is still in office. So in order to avoid such conflicts of interest happening, this is a reason why there's such a focus in the Venice principles to ensure the independence and to protect the integrity of the office. Yes.
Okay. In other words, if, let's say, somebody did whatever, all these horrible things that were explained there, that public protector would be immunized even after leaving office.
Even after leaving office.
Let alone while they are serving the office.
Yes.
All right. Then this is what I call, if you are a religious person, can go and read Matthew 27 about Pontius Pilate. It says, the states shall refrain from taking any action aiming at or resulting in the suppression of the ombudsman institution or in any hurdles to its effective functioning, and shall effectively protect it from any such threats. That's the issue of reprisals, the an illegal suspension by the president, and so on. Now, if states have a duty to ensure that this does not happen, I know I've asked you this question before, is there room then for a parliament to say, well, as far as those threats are there, it's got nothing to do with us?
The particular provision speaks to states in the abstract, and I think when they say states, they mean all the three arms of government. So it speaks to the government as a whole, as one, that they should refrain from occasioning any administrative or legal threats against the office of the ombudsman.
Thank you. And by the way, to carry on with my biblical allusion, Pontius Pilate knew that, participated in the crucifixion of Jesus Christ, knowing that he was innocent, but he was scared of losing his job or being in disfavor with Caesar. That it has nothing to do with anyone in this room. But I'm just saying that is it that kind of behavior of saying, look, I probably know that you are innocent and I'm washing my hands of the blood, but still carrying out the function against the threats, obvious threats. And threats, I mean, yeah, objectively, it might not be a real threat, but it might be a reasonable perception of a threat because the person is being investigated or whatever. Can a protector, and I know I'm asking this for the third time, can a body entrusted with the protection of the public protector absolve itself from the responsibility to protect her from those threats? And you'll see just now why I'm asking this question so many
Yes, the
times.
institution of the ombudsman was created to investigate the executive and to be accountable to parliament. And the reason why that was so was to ensure that through the principle of the separation of powers, the office of the ombudsman can seek refuge and shelter from Parliament against the excesses of the executive.
Thank you. Thank you. You see, that's the best answer so far. All right. That takes us, Madam, to page 344. And this is now Honorable Kajuju's territory. And if I'm sufficiently provoked, I'll call her as a witness to defend her document. Can you go to 344? But you also have operated that level. You're the treasurer.
Yes. I'm the
Okay, so she can delegate that task to you. Now here, and this is quite important for this question that I've asked you many times. The IOI, International Ombudsman Institute, has seen it fit to produce a document called 344.
Chair, the difficulty with this, trying to navigate these documents is that they are saved separately.
Okay, no, that's fine. Sorry, Tsepo. I thought that this one is called the IOI Guidelines on the Support to Colleagues Under Threat. We submitted it, I think, on Friday and again yesterday. So that might assist you in finding it. Thank you so much. Thank you. Okay. Yes. Okay. Page 344, Madam Sokoni. So this is the document which was approved by the Board of Directors in Bangkok in November 2016. Now here, this one deals specifically with the threats that we've been talking about in theory of reprisals, unfair suspensions and that kind of thing. Yeah. And it says the purpose of these guidelines is to establish principles and courses of action to coordinate IOI support for ombudsmen coming under threat, facing reprisals or operating under difficult circumstances. Sorry, the joke there is that this document was obviously written by an English-speaking person, because they've put ombudsman in plural as if it was English, yeah. But it's actually a Swedish term, but that's another one. But anyway, it says from IOI, we're aware that those threats are arising also in the middle of growing challenges and threats to human rights in many countries. In other words, the threats against public protectors become part of the general lawlessness or abuse of human rights in a particular country, correct? Now, this document, I found it particularly depressing. Let's go to definition at 345, because I hope Madam Kajuju is not listening. I think if she uses this document, we are gone. The definition says, yeah, threats to ombudsman institutions come in a variety of forms, but have a common denominator. They come as a direct response to the complaint handling work of the ombudsman and their efforts to protect human rights and fight corruption. Okay, so again, fighting corruption is usually against the powerful forces, public and private, in any society, correct?
Correct.
And then it says, for the purposes of these guidelines, threats should be defined as any action that is directed towards an ombudsman institution or an incumbent, directly or indirectly, that potentially puts the independent operation and exercise of the ombudsman's duties at risk. All the examples we've said before, unlawful suspension, direct threats, even physical threats to physical life, correct?
Yes, if you could refer to Annex 1, maybe, I don't know what page it is.
Sorry?
They are listed in under
Yeah.
Annex 1.
Yes, no, we're going there. We're going there. That's the part that is depressing me. Okay, can I just say, I think broadly, we've covered this in the morning. Honorable Kajuju would assist us there. I mean, the worst case scenario is if someone doesn't if someone practices this or a country encourages this or turns a blind eye to such threats, it could potentially face expulsion. I know it's not as easy as that, but it's one of the consequences, correct?
Yes.
Thank you. And now, and one of the things that the IOI at 347 may do in a country, if a country does anything that looks like is in breach of this protocol, would be, I think, yes, bullet 1, 2, 3, 4, to establish a commission of inquiry to take evidence in the country concerned if necessary and report to the executive committee. Obviously, we know where that might lead us.
Yes, that is correct.
Yeah. And sending an IOI delegation to study the problem on the field. Well, they're already here.
That is correct.
Okay. All right. Now, here's the depressing part. At page 349, there's a list of what you call possible threats to ombudsman institutions. Okay. And they're listed there 14. I've added a 15th one, but which I call unlawful retaliatory suspension. But we'll get there just now. And the depressing part is that actually, I think South Africa, given this process that's taking place here, fails all 15 or 14 of these. But let's see what the scorecard would say. This process, and maybe before we get into this, let me preface it by asking you. You said in one of our consultations that one of the things we are missing is that the world is watching us as we're doing this process. And also you linked that to the what you call the Pan-Africanist mission or role of South Africa as to lead in these kinds of things. Can you just talk about that? The world is watching, we know, because you're here and Madam Kajuju is here, but maybe you are right, maybe we are too internally focused. What are the dangers or the opportunities in us doing this exercise properly or wrongly or improperly? Yeah.
The South African example is a particularly poignant one for me because from the time of your independence, you have strived to ensure that you implement democratic constitutionalism in this country. Your constitution, I think, is a model for many, and you have established the appropriate oversight institutions in this country. Particularly the institution of the Ombudsman has been a leader in Africa simply by the fact that the African Ombudsman and Research Center is housed in this country. And this country has also supported ombudsmanship. So you are a leader. I would call you a leader in the field of human rights and ombudsmanship in Africa. So what has been going on here in South Africa is actually very telling on the continent. And that is why it is important for us. This is the reason why in the OR Tambo Declaration, we have included the African Union Commission in that document. And under, I think, Article 14 of the
OR Tambo.
on the Charter on Democracy, Elections, and Good Governance, the African Union's Charter, we have agreed with the African Union that we will spread the concept of the ombudsman in Africa, in the spirit of course, Pan-Africanism, really to ensure that institutions of good governance are established, especially the institution of the ombudsman. So I say this because recently, of course, there was a judgment that came out of South Africa. I think it was economic freedom fighters and the Reserve Bank, the Speaker of the National Assembly. Yes, yes. Where the powers of the ombudsman were discussed in that paper, in that judgment. And I think it was this, I hope I have the right case.
I think, yeah, no.
It's Reserve Bank of South Africa.
You know, if you're talking about Reserve Bank, then that's a different one. If EFF is the Nkandla report, the one we discussed in the morning, which was about binding reports. You are probably talking about Public Protector versus South African Reserve Bank, which is a 2019 judgment. 2019 volume 6 and all that. Yeah. Okay. Yes. You're talking about the one to do with Reserve Bank and the mandate and amendment of the Constitution.
Yeah, where the Constitutional Court, I think, challenged the mandate of the Public Protector, stating that it's not, their powers are not equivalent to a court.
Yes, okay, good.
Yes.
No, then yeah, you're talking about the Reserve Bank. That's the CX. It deals with one of the charges here. Yeah. So
Exactly.
is the judgment you're talking about where there was a majority judgment and a minority judgment of the Chief Justice?
Yes.
Okay, yes, that's the Reserve Bank judgment. Yes. Okay, now, okay, we'll come back to that judgment. I'll deal with it to you first thing when we're dealing with the judgments at later on. By the way, just for my own edification for now, so that I know whether to lead you on that judgment or not later, or how to lead you on it. Just high level, the majority in that judgment it dealt with some of the things we're speaking about here. Scathing criticism to the Public Protector and even imposed personal costs. And the minority judgment, I think, well, was of the view that the principles of Public Protector of an institution like that would be breached if the court went that far. Which of those two judgments, the majority or the minority, do you agree with?
Well, speaking as an ombudsman, really, I must agree with the minority judgment. Yes.
Yes. All right. We'll get back to that at a later stage. You were now busy telling us about the AU involvement, and just for quick reference, Chair, it's page 271. I'll read it out. That's the last page of the OR Tambo principles. it says implement measures aimed at accelerating the implementation of the AU shared values, giving priority to the AU Charter on Democracy, actively disseminate provisions of the Charter that relate to governance with special attention, and so on. Is that the section you're talking about where the next stage is to try and have these principles adopted at AU level? And it's a
Exactly.
double question, which is how far are we in that process? Have we yet succeeded?
At this juncture, I think because of the COVID, this is what interrupted the whole issue. But we do have, I think, observer status at the AU. And I hope we'll now take it up further now that the COVID crisis is over.
Yes. And by the way, talking about expulsion, which we spoke about earlier in the context of IOI, do you know what the situation is with the European Union vis-a-vis membership of that body of a country that flouts these principles?
I can't recall the particular provision. But I must say I was informed by one of the members of the IOI Board of Directors that a member that is does not have an institution of the ombudsman cannot continue to be a member of the EU, or if a country is applying to be a member of the EU, they must have an institution of the ombudsman, otherwise they cannot be admitted as a member of the EU.
Yes, no, what I'm getting at is, well, you can have an ombudsman institution, you can call it what you like. But if you had one that does not comply to the Venice principles, for example, would you be admitted?
If a country is not compliant, I wouldn't be able to say. I'm not an authority on the EU. I wouldn't be able to say.
Okay.
Yes.
All right, we'll find that information. Now, the reason why I was prefacing that question is, insofar as you are trying to get the AU now, African Union, to follow suit, would that be the direction that hopefully one day membership, or rather the having a compliant institution of ombudsman would be one of the criteria for participation at that level?
Exactly.
Thank you. Okay, now let's go back to, you can see I'm running away from that list that I was saying is depressing me, but we have to go to it. So the first thing is restrictions of budget or staff on budget or staff. Well, we feel I think the witnesses that have come here have said that the budget is clearly one of the most serious constraints.
Just a pause.
Sorry,
Madam
Chair.
Mpofu,
Given the nature of the witness, I haven't kicked up a fuss about leading, but I think if the witness is going to conclude that the country has failed in any reasons of this, then it must be based on reasons that the witness believes so, not Advocate Mpofu's evidence in that regard. I mean, the leading is.
I'm not leading anything. I don't know what you're talking about. I'm saying that the witnesses that have come here, Ms. Mutsisi, Tejane, maybe to some extent Mokhaladi, I'm sure there are more, have all said that the budget, there's even a document, I can't remember, it was supplied to us by you, which specifically states that one of the weaknesses in this country is the inadequacy of the budget. I think this is almost common cause. So I
No.
don't know.
No, Chair, there's a difference between a suggestion that the budget which is provided to the public office, public protector's office is inadequate to meet its needs, and a suggestion that as a threat to the institution or as punishment or form of retribution, money is taken away from the institution.
I didn't
And
say, who
no,
said
you
that?
didn't say that. I'm suggesting to you
Oh.
that when you do that, let's just be clear about what is being put to the witness and the witness is saying yes.
Okay, thank you, Advocate Bauer. Advocate Mbofu.
Okay, thank you, Chair. All right, Madam, I don't know what's happening now. Yeah, I'm just giving you information that about 3 or 4 of the witnesses which were called by the evidence leaders have confirmed in writing and in memoranda that were presented here. And I don't think anybody denies this. Even our parliament cannot deny it. It's because we have many other demands like everyone else. But it's common cause that there is inadequacy of the budget for the Office of the Public Protector. And the Public Protector has said it probably in every meeting she has ever attended to the Portfolio Committee. So I don't know what the issue is. I'm saying to you that you, because you are an outsider, unlike me, that, or even more, you were not here to listen to all the witnesses. I'm saying that this issue should not be contentious because the witnesses of the evidence leaders have confirmed it. Can you just accept that as information?
I will state that most ombudsman offices are underfunded. Even in Africa, even in Europe and America, they complain about the funding to the office. I can't say about the funding to this office, but I know for a fact that most offices are underfunded.
Yes, thank you very much. Okay. And then the next one is unlawful removal of incumbents. That's another threat, isn't it? Let's not be generous. The heading is called possible threats to ombudsman institutions. Another possible threat would be an unlawful removal of an incumbent. Let's say, for example, arising from a flawed or unfair process, correct?
Yes, we have had examples where ombudsmen have tried to appeal for assistance either to AOMA, the IOI, where they feel that they're being removed unlawfully. So that's a reality, does happen.
Yes. And then the next one is the failure to appoint or elect a new incumbent. Okay, that one, we can leave it at the level of a threat. Obviously, something like that might happen if there's, let's say there's a legal process that interdicts the appointment of a new incumbent.
Yeah, it is a threat, actually. We have had, I think, one African country that has even completely I think it has completely removed the office of the ombudsman, even from its constitution. The office just doesn't exist. I can't remember which country it is. So for us, it was a threat. It was a concern. And there are some countries where there's supposed to be an ombudsman and there's no ombudsman appointed. Yes.
Yes. And by the way, talking about new incumbents, I'll ask you this, I'll try to ask it theoretically. If a particular incumbent, let's say, was left with 6 months of her office, of a term of office, and a particular country pursues the removal of that person at the estimated cost of 1 million rand per day, given load shedding and all sorts of things, would that, oops, I shouldn't have mentioned load shedding. Would does that even make sense? In other words, if you have a costly exercise to remove a person who's halfway to the door, basically. And I'm saying that apropos the threats that might pose, for example, to the process of appointing a new incumbent, let alone the process of handing over to that new incumbent by the old one, which is, what would it be indicative of? And I'm just exaggerating for effect. Let's say the person was left with 2 weeks, and then we start a process like this, and spend so much money and time and resources and lawyers and what have you. Is that consistent with, or rather, should that be seen as a threat or something to be encouraged?
Really depends on the gravity of the charges that have been pressed against that
Yes.
particular ombudsman.
Yeah, let's say, yeah, if like they killed everyone in the office, I'm sure even if they were left with 1 day, we have to do something.
Yes.
But go back to the examples that I was giving you
Yes,
about,
if
where it's just
there
HR
is,
and judgments and also.
yeah, if there is actually no substantial charges against that person, it's just on the whim of any authority to just have that person removed, of course, it can be perceived to be a reprisal.
Yes. Thank you. Right, the next threat is called political pressure on incumbents. Oh, there. I don't even want to bore you with the details. I gave you an example of the judgment. Yeah. So the next one, number 5, is incorrect charges on incumbents resulting in arrest. Now let's pause here. You mentioned the Reserve Bank case, where the judgment that you don't like, the one that imposes personal costs on the public protector. What's wrong with that? In terms of what we've been discussing, the principles.
Well, really it looks like the functional immunity of the office has actually been stripped away completely. But having said that, I don't know how it is here with the South African system, but I think in our system, for someone to be to take on the personal cost or the cost of another party, I think that person would have had to be, the office holder would have had to be a party to the proceedings, really, from the way I understand it.
Yes. Okay.
Yes.
No, fair enough. That's true. Well, I tried to argue that once in the Constitutional Court, it didn't find favor. But assume for a minute that the person is a party. I'm saying that from an institutional independence point of view, is it a good thing to then pursue the person personally as a person?
No,
For work that was done in the capacity as a public protector or an ombudsman?
the person is functioning officially
Mhm.
in their office. They are not carrying out a personal duty. So it really compromises the independence and integrity of the office for the officer to be asked to take
Mhm.
responsibility
Yeah.
for actions that were carried out in an official capacity.
Thank you. And as if that's not enough, for the same transgression, quote unquote, of the CX matter, this one offended very big, powerful people. Yeah. So apart from being mulcted with personal costs, the public protector is also facing criminal charges. And that goes to that threat of incorrect charges on incumbents resulting in arrest. Okay, sure. Thank God she was not arrested. But for the very same thing for which you say she should not have been subjected to personal costs, the very, very same thing, she's also being charged criminally. What does that do for institutional independence?
I think this goes to the very heart of ombudsmanship, that the office of the ombudsman was set up to investigate the executive. So this is just my opinion. I don't think that the executive arm of government should be allowed to get back at the ombudsman using the court system, because these are the costs. First of all, in the issue of the costs, these are the costs which were supposed to be borne by the respondent institution. And then they are cast upon the public protector personally. And then secondly, to have criminal charges cast against the public protector, again, arising from the same sort of circumstances, it really does, it does sound like victimization. I'm really sorry to say it. It's a bit much, because this is, again, I must go back to my previous statement that this is an office that is constituted as a corporate soul. So this is a single person in an office being asked to shoulder the responsibility of an entire organization, because there's an entire system that is behind her or him.
Yeah. Well, it is what it is, as they say. What about double jeopardy? Is it if the person has already been punished rightly or wrongly in the court, is it fair to then punish them again in the criminal courts for the same thing?
Repeat the question, please.
If a person has been punished by punitive cost, the word punitive means punishing. If a person has been punished by the imposition of punitive costs, is it fair to then punish them criminally for the same thing? It's called double jeopardy.
Okay, I mean, in the criminal law, you will fine you will find an accused person, you know, at the end a convict, and say, well, you pay a fine, and failure to your paying this fine, you'll face imprisonment for so long. So this means that it's an either or situation. It can't be both.
Okay, thank you. Then, okay, the next one is organizational changes. Okay, we can jump that. That obviously follows from, for example, an unlawful suspension, then will lead to organizational changes. The next one says changes of mandate or statute legislative initiations that could impact on the office. I think we've dealt with the issue of the mandate, that the mandate should, or rather for example, the thing that happened in your country, where the mandate was changed from an executive to a parliamentary process. Let's assume in some, earlier you and I called a step backward, that you then move from the parliamentary framework back towards an executive framework, surely that would be a threat, correct?
Yes, yes.
All right,
Let's pause there,
Sorry,
just to
Chair.
take tea break,
tea break. Oh, thank you, Chair.
15 minutes.
Yes.
We'll
okay,
be
that's
back
fine.
at 1:45. Thank you.
Thank you, Chair.
Recording stopped.
we proceed. Over to you, Advocate Mbofu. Thank you, Chairperson. Sorry, I just lost my place. That's fine. Thank you. We're at page 349. Yes, okay, I'll try and go through this quicker. I think we just did number 7. Number 8 is reduction of formal independence. We covered this earlier in the morning. That's obviously a threat to the institution, correct?
Oh, yes, please.
Yes. And that reduction can come in many ways, either undermining functional immunity or, subjecting the public protector to unnecessary pressure and all that. Okay, and then unstable political environments. Okay, so I spoke about factionalism. So this may or may not be a threat, again, depending on a country. In your country, for example, we've heard that there have been 5 different governments, 3 different parties.
Yes.
And yet that was not used. It was not really a threat. Well, maybe it was, but at least not one that was unmanageable. You may share if you are free to do so. You don't have to, whether there were any challenges around the changes of government here and there, but which were managed.
No, there were no challenges, except that there was just ignorance. I think ignorance is one of the ombudsman's biggest challenges. Yes. So you would get people who, when there's a change of government, who would ask, but you're still in office, so just not understanding that there's that aspect of security of tenure for the office of the ombudsman.
No, fair enough. Okay. No, I think that's a fair statement. So ignorance, sometimes it's not that people are being malicious, but they're just sheer ignorance.
Yes.
So for example, if someone says, well, we're just going to be bound by judgments, or a suspension has nothing to do with us, it might not be coming from a place of being malicious, but just pure ignorance of how these things work, correct?
Yes, definitely.
Okay. And then it says defamation of incumbents and or staff or media. I've told you that in our case, the public protector, there's a political party that called a spy from day 1. In fact, from day 0, before she started on day 1. And that was a subject of a defamation suit that went up to the Supreme Court of Appeal. But that's another way of undermining the independence of public protector, isn't it? Just pure sheer insult.
Yes, it can happen, definitely.
All right. And then administrative or judicial harassment. I read you out the judgment about reprisal from the president in our case. The judicial harassment, I don't know about that, but it says administrative or judicial harassment. So that both the administration, which is the executive side, or the judiciary could be an instrument to harass a public protector, correct?
Yes, definitely. The administration could be prosecuting or commencing civil actions against the ombudsman, and the judiciary may also play along to the gallery. Yes, it's possible.
You also said something earlier about the judiciary. And this is about the next topic that we're going to discuss. But just in this context, that the judiciary would feel less threatened, I think, in a situation where the remedial action is recommendations
Yes.
than when it is binding. Can you explain that? And in what way would that play into this space of the judiciary being part of the threat?
I think from my experience, it seems like they perceive the Office of Ombudsman as creating a parallel court system when you give the ombudsman binding powers. But when the reports of the ombudsman only have the effect of a recommendation, usually there isn't so much interplay with the judicial area. They have no reason to interfere in the functions of the office.
Yes. And okay, well, I'll make that example maybe later when the public protector testifies. But one of the or two of the judgments in this particular case relate to a section of the Public Protector Act that gives the public protector the discretion to investigate matters that are older than 2 years.
Yes.
And well, I almost said the obvious there, but the interpretation of that section, there are two possible interpretations. You can interpret it as the public protector has power, extensive powers, but she has a discretion to investigate even if something is 100 years old, if it's important. Or you can interpret it as a normal prescription thing that says thou shalt not investigate something that's over 2 years, even if the person stole 200 billion rand. And if it's 1 week late, then you can't touch it. And this is the kind of issue where this in the judgments that I'm talking about is the Gordon and Pillay judgments. The courts went to say that no, you may not, the public protector is basically prohibited, and she even got another personal cost for that, from investigating the rogue unit in that case, just because it was discovered, or rather it was brought to her X number of years after the actual activities. Now I'm saying in that kind of space, do you think that it would, if it's a binding regime or a recommendation regime, that kind of clash between the judiciary and the public protector might have been avoided?
Yes, definitely. It was going to be avoided for the fact that nobody has to worry with the report is only supported by recommendations, but where the report is supported by binding decisions, then people worry and they say, what is the effect? What is the effect of this particular investigation going to be? But having said that, again, it is in a way an injustice for the members of the public when the time limit for submitting complaints to the Office of the Public Protector is read very, very narrowly, because there are always exceptions to that rule. For example, for poor people who come from the rural areas, they may not know that they can actually appeal. They may not have the money to actually reach the Office of the Ombudsman, and they may take more than 2 years to bring a complaint to the Office of the Ombudsman. So usually that particular clause is read very, very loosely. And it actually gives even the ombudsman discretion in a lot of jurisdictions, discretion to have some exceptions to the general rule.
Yes.
Yes.
Well, okay. Well, in our country, it has been now twice or three times actually, I think, even in the James case, it was seen as a prohibition rather than something, let's call it an enabling statute, which actually gives her the leeway to intervene if the situation so demands. Yeah. Okay, and then attacks on incumbents, verbal or written. Okay, that goes with the spy example and defamation. It's the same thing. And I think she's even been called the enemy of the state or something. Ill treatment of incumbents. Well, we can spend the whole day on this. What happens? Why do people lose their humanity and treat a person like as if they are an object? They don't have family, they don't have any feelings. They can just be vilified and ganged up against and subjected to blatantly unfair and biased treatment. What drives that? Okay, I know with as far as the executive is concerned, it's obviously a form of reprisal. But generally, if another institution such as Parliament or any other institution?
I think in a lot of instances where these things are happening, it is because the Office of the Ombudsman is not being accorded the appropriate protections according which have been set as a standard at international law. So we can again put it down to ignorance, I think, and for want of better words, I think sometimes it's just overzealousness, you know, not knowing that there are particular standards that have to be accorded to this particular office when you're dealing with this particular office, and looking at the nature of the job that this particular office holder carries out, and then ensuring that because the office holder is carrying out a very unique responsibility, therefore there have to be appropriate rules, regulations, and standards that have to be accorded to this office when you are carrying out any process against that office.
Okay, and yeah, thank you. Thank you. And the double standards, what brings that about? For example, what drives a political party or individuals from acting like, if it's the public protector, the fact that she might be reviewing the process, they say, no, we're continuing. But when it's one of their own, if it's the president, then because there's a review, no, we're not continuing. Party line, what have you? What brings that kind of double standards on opportunism and duplicity?
For that, I think, again, I will speak to the fact that this particular office, again, is vulnerable because it investigates the executive. So double standards are going to be used in order to rein in the office. Yes, to ensure that the office does not carry out its duties, the duties that it was accorded by statute or by the Constitution.
Yes, okay, maybe I'm putting the question too vaguely, or because you're not familiar with our situation. I'm saying that if literally the same logic applies to two situations, let's say it's the impeachment of the public protector and the impeachment of the president. And then the same people behave differently. In other words, in the one case, the ill treatment comes in the form of, well, we don't care whether you're going to court or not. But in the other one, it is, okay, because you're going to court, we will spare you. Another, coming from the very same people. What does that say about the integrity of a country or the threats to the first institution?
Well, it is definitely a threat to the office of the ombudsman when two or more entities come against the office and try to use whether it's the law or they try to use administrative rules and regulations against the office. So it is a definite threat to the office, and that is the reason why.
Okay.
Yes.
And then the last one on that list is death threats to incumbents and staff. Okay, we know that there have been security threats to, and I'm sure it's not unique to us. One of the guidelines say that there should be adequate security measures provided, correct?
Yes, that is correct.
And then, as I said, the last one, which I added, number 15, just to make it a round figure, was an unlawful or retaliatory suspension. That would be a threat as well, correct?
Yeah, it falls under administrative or judicial harassment.
Yes. And while we're on the subject of judicial harassment, if we have a situation where the courts make it fashionable to punish the public protector with personal costs, would that form part of judicial harassment?
Yes, personal costs, really, I have to agree that it forms part of judicial harassment. It is totally unacceptable.
Yes. No, I'm saying, yes, you've made that point. I'm saying personal costs, let's assume for now that the personal costs was an acceptable way of dealing with the public protector. I'm asking a different question, which is, if the courts make it fashionable, in other words, it's instinctive. This judge gave the personal costs, therefore I'll also give personal costs. And therefore the third one will also give personal costs. And it becomes literally almost instinctive to do so. What does that do for the independence of the office? This is the situation you said, you read the commissioner for SARS, the situation that was described by the Constitutional Court in the commissioner for SARS case.
Yes. It really weakens the office because the courts of law are a place of refuge. If you cannot go to the courts of law for protection, if there is no impartiality, then the office really is completely stripped of the basic protection that should be accorded, not even the office holder.
Okay, thank you. Yeah, we'll deal with that. Well, you should have accepted that judgeship, because that word was exactly what Judge Madanga used to say, if you do that, you weaken the office, and he said, therefore you weaken our democracy. But we'll deal with that tomorrow morning when we do the cases. Right, now, the general question, we've gone through this list of 14 or 15 criteria, and to be generous, we, as I say, we probably score less than 10%. Now, what should a country do? I mean, objectively now, forget about partisanship and so on. If you had a situation like this process here, and you call an objective person and say, how do we fare against these 15 criteria? And you find that on all of them, or 14 or 15 or 13 of them, you are found wanting. Obviously, you should be worried as a country. But what lessons can be drawn from that situation, and what should we do going forward? If I'm right that we failed dismally.
I think going forward, it's very, very important for states to look at the institution of the ombudsman, not just from a narrow perspective of as a national institution, but to also look at its international personality. Because really, we are trying to build democratic institutions, for example, for Africa, throughout Africa. And it's very, very important that what we reflect in our jurisdictions can also be replicated in other jurisdictions. So it's just an issue of asking oneself if what is going on in my jurisdiction can be allowed to happen in another jurisdiction, and just adhere to the standards, really. Yes.
Thank you. Okay, now I want to deal with shall we call it the virtues. It can be nice if you are in power to have a situation where you're going to be scrutinized by an ombudsman. And, you know, when you are supposed to have all the power to yourself. But I think our founding president, Mr. Nelson Mandela, explained it so well that it is actually the government volunteers to have such scrutiny for the sake not of itself, but of the public. And again, that's a point that always missed in these conversations. And maybe the best way to illustrate it, Madam Sokoni, is by going back to basics. You've said this is an institution that started more than 300 years ago, actually 310 years ago. And it started in Sweden, as you indicated, in 1713.
Yes.
And I'm now going to paragraph 10 of your statement. 1713, just to give you perspective, was 60 years, we were still fighting different things. 60 years after the arrival of Jan van Riebeeck, and 30 years after the arrival of another chap called Simon van der Stel, after whom a place called Stellenbosch was named. Yeah. So the wisdom of that king of Sweden is something that if he didn't do what he did, we wouldn't be sitting here, for example. But what do you think drove the Swedish king in 1713 to say, I'm an all-powerful monarch, I've got all this power, but there should be an institution that actually scrutinizes me on behalf of the people, from which we have all benefited, well, depending where you sit. I think Advocate Mkhwebane has not benefited from that. She's suffering from it. But as people, if you can just then help us to trace this institution over those centuries, from the 18th century when it was established in 1713, up to where we are, broadly speaking, not year by year, because otherwise we'll be here.
There's a pause. Advocate Bauer.
Sorry, Chair, in assisting my colleague in us being able to move on. I'm not sure if last year we had this conversation. I thought we did, but we might not have. We don't take issue with paragraphs 10 to 16, which set out the historical background And unless it's got something specific to the motion, we're happy to accept the contents of those paragraphs as they stated in the affidavit.
Okay, thank you. And we're going to move.
No, thank you, Chair. Yeah, no, that's very useful, yeah. But the point I'm really making is maybe a more profound one, more than whether the evidence leaders accept the evidence or not. It is to describe the nature of an institution where the holders of power surrender that power voluntarily for the benefit of the public. And I'm saying from 1713 up to now, 10 years later, that is still the underlying principle of ombudsman institutions, isn't it?
Just answer it very quickly, very briefly.
Yeah.
So when the Swedish king, I think there was some disturbance in the kingdom, he had fled Sweden
Mhm.
and he had actually gone to Turkey for refuge.
Mm.
So when he went to Turkey for refuge, he found this concept of an official
Mhm.
who handles complaints from the public
Mm.
on behalf of the ruler of Turkey.
Mm.
So he took this concept back when he went back to Sweden and I think made peace. The only way he made peace was to introduce this concept of the ombudsman, to say I will cede some of my powers to this official who will take complaints against the excesses of the king.
Mm.
And eventually, I think as the institution evolved by 1809, they had set up parliaments and things like that. And this official became answerable to parliament and not to the king. They had refined the system. They were refining the system from 1713 up to about 1809. They had refined the system.
But 100 years. Yeah.
Yes. So now to take the context to the present, when Tanzania set up the office of the ombudsman in 1966, the Tanzanian president then, I think, had set up a one-party state. And because he had set up a one-party state, people were anxious. Now, with this one-party state, if we have complaints, where are we going to be complaining to? So this is when he set up this office of the ombudsman to tell people that if you have a complaint, you can go to the ombudsman and the ombudsman will investigate all officials. I think they were investigating all officials, whether they were for the legislature, the executive, or the judiciary. And this was replicated in Zambia. In 1973, the 1973 constitution was the one which barred multi-party politics. And Dr. Kaunda set up a one-party state. And he too, I think in order to convince the people that yes, this one-party state can work, he then established the office of the ombudsman. It was then called the office of the investigator general. So in that sense, you can see that the office of the ombudsman was seen as a very powerful institution which could help to protect the public against the excesses of the executive. So from these three examples, I think
Thank you very much. I
Submit.
think, yes, that covers that topic. Then you've dealt with, I think we've already dealt with the interplay between the three arms of the state, with what they should do versus what they should not do. In other words, they should be cross-checking each other, not collaborate against the public protector. We've dealt with that.
yes, well, I could also explain a little bit about that. In a proper working classical system, the ombudsman is, as I said, is appointed and be dismissed by the legislature. And the executive facilitates the establishment of this office and at the same time funds it. And then the judiciary gives this office the conditions of service. And by the judiciary giving this office the conditions of service, it it helps the office from being isolated. Because if the office is isolated, the conditions of service are just hanging. They are just being picked at the discretion of either officials of the executive or of parliament. This becomes a threat to the office of the ombudsman. So this is why it is very, very important that all three arms of government contributes to the establishment of the office. And this works as a protection for the office of the ombudsman.
Thank you. Sorry, I was missing my phone. Yes, now you've also, I think we've covered the, or rather, let's just do this so that we get it out of the way. You've made this reference to the classical versus the hybrid model and so on. Can you just very briefly explain what that's all about vis-a-vis the historical account of this office having evolved for the past 300 years and the first office in Africa having been established in 1966, as you say. And by the way, is it correct that the Africa's first ombudsman institution, predated some of similar institutions, even in the so-called Western world?
Yes, the Office of the Ombudsman in Tanzania was established in 1966. The United Kingdom established its office in 1967. And a lot of the other countries started establishing ombudsman offices much later. I think even the United States and countries like that.
Yeah.
Yes. So, yeah, I just wanted to stress on the issue of the conditions of service. When the conditions of service of the ombudsman are not certain, it becomes a very, very big threat. And a lot of ombudsman persons are having this problem. So the issue of isolation, the ombudsman becomes isolated. The ombudsman cannot go to the executive, cannot talk to the executive. The ombudsman goes to parliament, and through the whip system, again, the ombudsman becomes defeated. And then, so the only other protection to prevent the ombudsman from being isolated is to have the conditions of service under the judiciary. So this is the system that is pertaining in Namibia. In Namibia, the ombudsman enjoys the terms and conditions of service of a judge. So the ombudsman doesn't have to fight for his own terms and conditions of service. He just waits, the judiciary themselves just negotiate with the government, and when they get their conditions of service, he's just written a letter to say, oh, these are your conditions of service, now you need conditions of service. It's a protection. Yes. Isolating the ombudsman to fight his or her own battles, especially with respect to the terms and conditions of service, is really a threat to the institution of the ombudsman.
Thank you. You know that what you've just said is probably lies at the heart of what we're dealing with here in many ways. So the Namibian situation is, I think, if it applied in South Africa, again, I keep on saying we wouldn't be here. When the public protector gives evidence, one of the things she will say talks to what you're saying now, namely that there are actually no conditions of service. You are talking about conditions of service which must be adequate or whatever. Well, here there are zero. You just get appointed in parliament, you go to Pretoria, and you'll see how you get by for the 7 years. Now, in that situation, is it fair? How can you even have a disciplinary process? Against what? You know, if Parliament fails or the appointing body fails to give you even a one-page thing that says, okay, you must go to work at 8 and finish at 5 and take this and the other. You just left on your own devices. And then when something happens, they say, oh, well, now we must chop your head. The same people who fail to give you conditions of service. Now, what you're saying is that in Namibia, it becomes easy because obviously the conditions of service of judges have been established over years. So all the public protector really has to do is to just fit in with that system.
Yes.
Now, what do you have to say about the situation where there's 0 conditions of service, not even one, well, except for the Act and the Constitution, which we can all read, but there's no conditions of service?
That is a real threat to the independence of the office.
Yes. So I'm sorry, I missed that. I was just checking with the public protector, which was saying just to clarify that point. It's what in normal parlance is known as a job description. There's no such thing. So the office kind of develops its own guidelines just to make sure that there's a way of dealing with the hierarchy, who does what. For example, she would delegate to the deputy public protector this and that power. Even that is left to her own devices, but we'll deal with that in another context. But can one who doesn't have a job description formally imposed, and I use that word advisedly, by the employer, quote unquote, be then disciplined by that employer, as I say, against what? What would be the yardstick?
I think these are the issues that go to the heart of the independence of the office of the public protector. So for in my situation, also the terms and conditions of service have not been given, but the new constitution states that where the public protector has to be disciplined, he will be disciplined in the same way that a judge shall be disciplined. So it goes to the Judicial Complaints Commission. Someone can take a complaint to the Complaints Commission.
Wow. Well, now imagine if we had that system of Namibia and Zambia, then the public protector it would have been impossible to suspend her, because in our case in South Africa, it also goes to something called the Judicial Complaints Commission. Then it goes to something called the Judicial Conduct Tribunal, and which is like the equivalent of this committee. And only once that body finds you guilty is the possibility of a suspension. And as I explained to you earlier, here it was for retaliatory purposes, it was accelerated. So the advantages then of having the conditions of service at least, and that includes remuneration, car allowance, whatever, being the same as that of a judge, also include that functionality of not having to reinvent the wheel, correct?
The last, I didn't catch the last.
Also, in one of the advantages is the fact that you don't have to reinvent the wheel. And
Yes, you don't have to reinvent the wheel, and you don't, there's no retaliation against the office holder, because like, for instance, in my case, the terms and conditions of service were for so long not known that at the end it was just put within the civil service structure, just somewhere in the middle. So it becomes difficult again, because now you are saying that there are a number of officials within the executive who are at a higher salary scale, it means that they're senior to the public protector. And how can the public protector investigate those officials independently? So it goes against the whole concept of the independence of the ombudsman.
Yes. Okay, thank you. Well, again, on the positive side for South Africa, and I think this might even be an area where, I don't know, I've not done a comparative study where we are better than others, I hope. But in Section 9 of the Public Protector Act in South Africa actually goes a long way towards that as far as protection is concerned. And if I'm not correct, it might be one of a few examples, but you can tell me if I'm wrong, where the public protector is actually protected by that section exactly in the same way as a judge, by contempt of court protection, where a person can go to jail literally in terms of Section 11 of that act for insulting the public protector. Well, not that it has stopped anyone from insulting her, but from at least theoretically, that section, I think Section 9(1)(b) actually uses the word in the same way as if it was a judge. So it says, if you insult there you are, thank you. Section 9, it says contempt of the public protector, which is basically the same as contempt of court. No person shall insult the public protector or the deputy public protector. And as I say, well, you'll be surprised. She's been called all sorts of things, including an agent of state capture and corrupt and what have you. And those people got away with it. Yeah. But anyway, it says, in connection at B, in connection with an investigation, no person shall do anything which, if the said investigation had been proceeding in a court of law, would have constituted contempt of court. You see, total protection. I think, well, at least in the South African context, I think is the only office that I know in this country that is protected with literally in the same, to the same level of a judge. So surely that's a good thing, correct?
It is a good thing.
So that Honorable Kajuju must reconsider her decision to expel us.
Yes, this provision actually for contempt of court is actually sort of generic throughout jurisdictions. It's there, and we also have it in our jurisdiction.
Good.
But it just comes to the conditions of service. When it comes to, they will give all the powers of the courts and say, oh, you'll be disciplined like a judge and everything.
Yeah.
But just when it comes to the conditions of service, that it becomes a
different.
problem.
Exactly. So, hence, you can be suspended willy-nilly. Okay, and just to complete that point, Section 11 of our Act, then that's where it is criminalized clearly. So it says, yeah, any person who contravenes the provisions of Section 9 of this Act or interferes with the functioning of the office of the public protector in terms of Section 1814 of the Constitution shall be guilty of an offense. Now, this is a very serious provision. It means any person, including this parliament, if it didn't have immunity in terms of Section 58 of the Constitution, any person who interferes with what you and I have called functional autonomy of the public, of the Office of the Public Protector, and interferes with how it hires people and all that, is guilty of a criminal offense and liable to a fine of not exceeding 40,000 or to imprisonment for a period not exceeding 12 months or to both such fine and such imprisonment. Now, assuming there was no such thing as parliamentary privilege, would this be a sufficient protection from any institution in this country, whatever it is? It could be the milk board or whatever, interfering with the functional autonomy of the public protector.
It does provide protection. It does provide protection.
Yeah. Okay. So if we remove parliamentary privilege, we could just send the police to round off, starting with the chairperson. Maybe we'll challenge him next time. We must have this meeting outside there in the street. No, sir, on a serious note. Okay, but all I'm saying is that, well, whether in practice it works or not, at least you can be sure that our legislature or the people who did this act in 1994 tried their best, at least at a structural level, to give teeth to the protections provided in section 181(4), for example, of the Constitution. Okay, thank you. All right. So, Chairperson, the next sitting, can you have it in Kukulate? Next to the police station. Right. Now, you were still explaining to us broadly the difference between, you just wanted to clarify that point, the difference between the so-called classical and hybrid model.
Yes, in the classical ombudsman system, which is a system which exists, I'll give the example of Zambia, for example, and Malawi, Angola, Mozambique. These ombudsman institutions investigate solely maladministration, and they are all accountable to parliaments, and they operate, because of that, they operate relatively without any conflict of interest. But where you have a hybrid ombudsman institution, so the hybrid ombudsman institution could be an executive ombudsman, or it could be a parliamentary ombudsman, but it will have multiple mandates. So it will have the mandate to investigate maladministration and or corruption, human rights, and like for example, with the Israeli office, the office of the ombudsman is also the auditor general. So they've merged both functions. So with the issue of the multiple mandates, I think the only drawback perhaps maybe that the ombudsman function may suffer. It may be relegated, and you find that the other mandates of, for example, human rights or corruption, they become more superior. They are given more attention by the ombudsman office. And secondly, when there is an issue of a mandate like corruption, the perception by the government or members of the public or the opposition may be that this is a law enforcement institution, and they want to have the office operate like a law enforcement institution.
Thank you. And I now want to come to the topic that, as I said in the morning, for me defines really your evidence. In your evidence, and when I summarize towards the end, there are maybe 4 or 5 broad themes, including these issues of protection, these issues of independence, and so on that we have covered. But if one were to reduce your thesis or departure point, it would be found in, I think it's paragraphs 23 and 24 of your statement, where you deal with the sorry, Chair, I'm just making sure that I'm correct. No, it's not. It's 23 and 24 of another document, but it's it's the last paragraph of your statement. Sorry, the last paragraph of your statement, which after you've referred to the case of economic freedom fighters, which we'll deal with tomorrow. But your central thesis is at paragraph 40, where you say, however, it is evident that issuing binding decisions make the ombudsman amenable to review of his decisions by courts of law. The courts also seem to feel threatened by the judicial powers of the ombudsman, and there's always a temptation by any one of the 3 arms of government to trim down the powers of the ombudsman, as evidenced by matters in Zambia and South Africa. Once the powers of the ombudsman seem to overlap or to be shared by any one of the 3 branches, inevitably, the institution of the ombudsman may have to be reined in by the arm which feels challenged. Am I correct that ultimately that you are a clear advocate or proponent of the recommendations model and an opponent of the binding decision model, for the reasons you've explained earlier?
Yes.
All right. Now let's go to that topic. In our situation in particular, as I say, as a young democracy, what's, apart from the cases which we'll deal with tomorrow, but just generally speaking, what would be your warnings, lessons, cautions, whatever you call it, against the binding decision model, which you are against?
First of all, the institution of the ombudsman, as I have stated previously, investigates the executive. And obviously the office will investigate very sensitive cases. And it's very, very important that during the course of investigation, the ombudsman has the complete cooperation of the respondent institutions, being the executive, emanating from the executive. So when the decisions of an ombudsman are binding, when the ombudsman is carrying out the investigations, the institutions of the executive feel threatened, and the ombudsman may not get as much cooperation, even though you have provisions like the ones that we have seen whether it is contempt of court for a party not to cooperate with the office of the ombudsman. So secondly, where binding decisions are issued, there's usually a temptation to try to influence the ombudsman to issue decisions in a particular way. There could be such a temptation, and it defeats the whole issue of having this office given the status of a judge, the high status of a judge, having the the institution created by a constitution, having a clause for the independence of the institution, all these other measures which have been put in place to protect the office of the ombudsman, it defeats the whole process once you just give an ombudsman binding powers. And thirdly, you open up the office to constant litigation, because respondent institutions will not be happy. They want to challenge the decisions of the ombudsman, and they will be dragging the ombudsman constantly to courts over the decisions that the ombudsman has issued. And fourthly, it just becomes expensive for the ombudsman. Now it has to create a budget for litigation. So the best protection that you can give an ombudsman office is to ensure that the recommendation, the reports of the ombudsman have the effect of recommendations and not the effect of binding decisions. It just ensures that the whole process follows through to the end without any interference, no ripples in the system.
Good. All right. Of course, yeah, as like everything in life, it's give and take. So what you're saying is that what we give in respect of the binding nature of the powers, which at face value seems like a good thing because, you know, it can't be ignored. We lose independence, vulnerability to harassment, budgetary constraints, and again, to come back to my refrain, it's possible, at least I won't put it higher than that, that had we had in South Africa the recommendations model, we wouldn't be sitting here because it's a what you call a ripple effect. We're here because there were judgments against the public protector. There were judgments because members of the executive in the main challenged the decisions. They challenged the decisions because they are binding. And if so, that chain reaction is clear. Well, for anyone who has eyes, that what has brought us here is in a way the regime that we've had since when was the Nkandla judgment? 2016 up to now. Because all the things you have mentioned here have happened here. The budget has shot up. This particular public protector has probably been in court for all her term. And now here we are. She's being harassed or given the ultimate death sentence equivalent of her office by simply being here. So let me put it this way. It seems to me then the only way to get out of that trap would be a constitutional amendment. And I'll be impeached in this country for suggesting such a thing. But on a serious note, is there any other way that we can come out of it except by amending the constitution?
This binding power for the remedial action reports of the public protector in this country, I think it was brought about by way of a court judgment. I don't know if the courts would be willing to review their own judgment, you know, possibly, because I think the Constitution does not say that the remedial powers of the public protector are binding. I don't know. I'm not an expert on South African constitutional law, but that is a way that it could happen. There is a case in Zambia where I know the Supreme Court's reversed its own decision, and in a particular case where they declared one judgment of theirs bad law.
Mm.
And yes, that's their own decision.
Yes, okay, well, as speaking as.
Apart from constitutional amendment. as
Yes,
you
no,
said,
I
apart from
think, yeah, the
constitutional-
chances of the court reversing its own judgment, first of all, are not very good. But even if they were, then one would have to wait for a case which may never come. Yeah. In the meantime, we'll be in this kind of situation. But okay, that's a debate you and I can have offline. The point of the matter is that the Nkandla judgment was, at least from the point of view of the Constitutional Court, an interpretation of our current constitution. And therefore, I was in that case, it related to particularly these sections 181, 1814, section 96, and so on. And even the Public Protector Act. And the sum total of what we argued there was that that interpretation means that we should have the binding model, and the court agreed. But so that's why I'm saying, short of a constitutional amendment, we should then specifically say it prefers the recommendations regime. I can't see us coming out of that here. By the way, in your country, you are in the same position. Just to be clear, so that you're not criticizing us for that just because maybe you come from a better situation. Isn't it true that the 2016 amendment in Zambia also introduced the binding regime?
Yes, it did.
And but unlike us, you don't have a court case, a constitutional court case, or do you, that affirms that position? It's spelled out in the Constitution?
It's spelled out in the Constitution, and we do have a judgment which stated that the binding decision-making power of the public protector is not absolute, and it can be subjected to judicial review by the High Court.
Yes, that's the court. Okay, that's the Zambian court case that said that that distinguish between court judgments and remedial action of the public protector.
Yes.
And it relied on one of our cases.
Yes.
From the SCA, Home Affairs versus Public Protector, correct?
Was it not a Nkandla judgment?
No. Well, yeah.
Or,
No,
yeah.
it was the judgment of Judge Plaskett in the Home Affairs case, but we'll get to that tomorrow. Let's just say it relied on a South African case.
Yes.
To do that. So once again, we led you into the opposite direction. But in that, was your office a party to that litigation?
Yes.
And were you on the successful side or the unsuccessful side? In other words, what was your argument? Was it that the powers should be binding, or that there should be a recommendation?
Our argument was that because the powers were binding, we could not be subjected to judicial review. And then the court disagreed and said, no, actually, insofar as it concerns the court, your powers are not absolute, and you can be subjected to judicial review. And they actually quoted a South African authority. And what
Yes.
was so, for us, what was so perplexing was that the binding powers of the reports of the public protector in Zambia are actually contained in the constitution very clearly.
Oh.
And whereas the judgment they were relying on here in South Africa was the one that actually imbued the Office of the Public Protector South Africa with binding powers.
Yes,
So it
Yes.
was,
okay. And with respect to your constitutional court, actually the judgment in Home Affairs was a judgment about whether or not the Office of the Public Protector is an organ of state and is subject to perjury or legality review. So I think they missed the point, but it happens to the best of us. Yeah. The case that we are talking about, just to be sure, is called Indeni Petroleum Refinery. That is in 2019, correct?
yes, that is correct.
Okay, okay, then yes, you did rely on, in fact, I got this, you must have just forgotten because I'm getting this information from one of your speeches. The case that they relied on was Minister of Home Affairs versus Public Protector, which is a 2018 case here of the SCA, not even the Constitutional Court. Okay. All right. So at least we are in the same boat as Zambia when it comes to this conundrum of binding versus recommendation, remedial action, correct?
Yes,
And you've said that the classical model or the correct model or the better model is the recommendation regime. Do you know, just off the top of your head, international, and maybe Honorable Kajuju would also have a perspective on this, whether most countries, are we and Zambia in the minority, or we in the majority, or is it 50-50?
we are in the minority.
We're in the minority, okay. Thank God. All right. Okay. And needless to say, then our regime, our common regime, is more prone to reprisals, all the things we spoke about, the threats and what have you, than the other model, correct?
Yes,
Right. Now, are you okay? Are you fine? You're not tired? Do you want a 5-minute break? We've been going on the whole day.
I'm fine, thank
Are
you.
you still fine? Okay. I asked you during the break, you said you were still able to push. Okay, please indicate if you need a comfort break or anything like that. I'll see what I can do. I'll ask the chair. All right. Right. Now, I'm going to the United Nations now. If you go to page 1 of your statement, and it's also paragraph 1, second. Yeah, thank you very much. Okay, just show me the big page. 218, yeah. All right. Okay, we'll paraphrase this because it's late in the day now. It would be safe to say, I call this, just for my own shorthand when I was making my notes, I called it the December movement. It looked like.
Sorry, Mr. Mpofu, we
Yes.
don't take issue with the section either.
Pardon?
We don't take issue with these paragraphs.
Oh, thank you,
want
thank
to
you,
short circuit.
thank you, thank you. That's good to know. Yeah. I call it the December movement because it looks like everything happened in December. But that's just the UNGA system is like that. When they do something in a particular month, then they'll always be meeting in that month. Yeah. But on a more serious note, we have a series of instruments from the United Nations, which have culminated in what you had earlier said, the embracement, if there's such a word, of the Venice Principle. Starting in December 1993, that's your paragraph 2, there was adoption by the UNGA, the United Nations General Assembly, of the Paris Principles, correct?
Correct.
And thereafter, over the years, there were further adoptions. I think there's one in 2010, 21st December 2010. And I just want to highlight there that again, the key words there were independence and autonomy, correct?
Correct.
And then in 2014, December 18, 2014, there's another resolution of the United Nations. And again, at paragraph 3, it talks about strengthening of independent and autonomous ombudsman institutions. The same 2 words that found their way into the OR Tambo principles, correct?
Correct.
Then we have the UN Resolution 68-171 that gave the same principles that we had in the IOI document, that ombudsman institutions should not face any form of reprisal or intimidation, including political pressure, physical intimidation, harassment of unjustifiable budgetary limitations. Chair, just to wrap up something that my learned friend had raised about the alleged leading. It's bundle D, page 3906. Let's just get that out of the way quickly.
You're not clear? Just come again, Advocate Mbofu.
Oh, bundle D 3906. Okay, maybe I should just describe it. Yeah, it's the witness statement of Ms. Mohaladi. I remember when I was responding to Advocate Bauer, I wasn't sure if she was one of the people who made, but she's one of many. Yes, it's paragraph 104, page 3906. Uh, 104. Yes. This is what she had to say. I'm just addressing the chair, just for the record, Chair. So the eradication of the backlogs and preventing the accumulation of further backlogs is therefore a priority for the PP, as it should be for any responsible executive authority. I can attest that it is also a priority for the executive managers and the COO. The main reason for the backlog is the lack of sufficient human resource capacity in investigation. This is a fact that is well known as well, to obviously just to some. This is a fact that is well known as the current and previous PPs have consistently been raising this issue and requesting additional funding from National Treasury and Parliament. The issue is also reflected in the various annual reports of the PPSA, as I indicated here. That's just to get that issue out of the way, Chair. And that's why I was putting it as if it's something that's, as the statement says, well known. Yeah. All right. We were at paragraph 4. So I was saying that we're highlighting those the measures should be implemented against political pressure, physical intimidation, harassment, and all that. Right. Then the important one, or rather, well, they're all important, but the most recent, I think, is resolution 72. Stroke 186 of the 16th of adopted on the 16th December 2020. And you say in your statement, this important resolution secured worldwide recognition of the Ombudsman institution and established the Venice Principle as the global standard for Ombudsman institutions. So that's why we spent so much time on the Venice Principles and we went through all the various articles. This is now from 2020 to the Bible, as it were, for these institutions that has now been accepted globally at the level of the UN.
Yes, that is correct.
Thank you. And to which South Africa is a signatory and quite frankly is bound by. Correct?
Correct.
And if South Africa is bound by the Venice Principles, and we have shown so many areas in which this process flouts those Venice Principles, what would be your message to the chairperson or the committee about the dangers of going that way? Assume I'm right, I may be wrong, that this process flouts most of those provisions.
I think the best that I can say is that we all as African countries, we are on a journey towards attaining the perfect, status of constitutional democracy and a respect for human rights. It's a journey. So when you're on a journey, sometimes you can go forward and you find that you have taken a wrong turn and you can come back and say, no, maybe this is the right route that I have to take. All of us are on the same journey. So it's nice to reflect. It's nice to come together like this and exchange experiences and see what it is that we can do for ourselves as Africans. And maybe my biggest plea is to you as South Africa to say, lead us. We are watching you. You are a proper constitutional democracy, and we want to follow by example. You already have the seat of ombudsmanship in this country. Sometimes you can try to lose a little so that you can gain a lot more for the larger majority, for the greater majority. As I was coming here, I was thinking about it, and I don't know if I'm making a mistake in referring to this. I thought about, I'm old enough to remember what was happening in Zambia, Tanzania. We're fighting for, the independence of other countries like Mozambique, Angola, Namibia, South Africa, we sacrificed, we were, not getting even small things like Coca-Cola, Fanta. If you got a Coca-Cola or a Fanta, it was a treat because we were refusing to trade with South Africa, the apartheid regime. So, for Rhodesia, then under Ian Smith, he would come freely into our country and just bomb us, So the frontline states decided to sacrifice something in order to ensure for the greater good. So I can just appeal to you. Yes, sometimes it's hard to say no. Let us go back a little bit and look at what we can do in this situation. But you are fighting a battle for the whole of Africa, for the ombudsmanship of Africa. So what message are we sending out there? All of us, so it's very, very important. So I think that's what I can say. Thank you.
Thank you very much. Well, I'm sure the chair has heard you and those that will listen to you and him. But maybe to put it more crudely, if this kind of thing that's happening here, that has been happening here for the past 7 months, continues, and you say the world is watching, Africa is watching, you've been watching, maybe closer than others, because you've been here, Honorable Kachucha's office has been here, she's been here. And if it continues unabated, let's assume that those words of yours are not listened to, and we just forge ahead to the bitter end, whatever that is. What do you think that impact of that would be to somebody out there, some spirited person whose wish in life was to be the public protector, and they've been gearing themselves to apply for the next round? If what is happening here continues, would you advise your child to apply for such a job?
What I can say is we're all at different levels of development. Some African countries have strong democracies, some have weak democracies, and we have to help them to move along. So let's help each other. Let's raise up the institution of the Ombudsman in Africa as a beacon. This is the only institution where the poorest of the poor can come and they can summon even the president of a country to say, because me, Caroline Sokoni, I've got a complaint that I've not been given my passport. I want you, public protector, to call the president to come and answer to this. It's the only institution which the poor man can call upon. And we shouldn't allow those poor people to lose hearts and to lose faith in this institution that has been set up for them. So I can just appeal to just say, it's a cry from all of us. And that's the reason why I'm here, from AOMA, to say, let us save this institution. Let us not allow it to die. Let us not allow people to start distrusting this institution. And just by applying the international principles that have been discussed at this session, I think it's very, very, very possible that this whole situation can actually be saved.
Yes. And I'd like your comment to this. You've commented about the use or the wisdom or lack thereof of what I call transplanting judicial pronouncements into Parliament on the notion that they are binding to courts as if they are also binding to Parliament, but that's a debate for another day. You've also commented about the breach of organizational or functional autonomy, which is associated with the fact that this particular process has been dominated by, as I told you, 15 out of 18 witnesses who are just employees and coming to air their gripes here and their personal grudges and all that. But what do you have to say about the fact that in all of this, whatever the cost may be, there is a cost? I think we're all clear on that. Bigger than money. I'm talking about a cost in a broader sense. But actually, what the worst thing that the public protector seemingly has done to deserve all this is that she wanted people to give services to the poor, chase the backlogs, make sure that the deadlines are met, produce clean audits so that governance is at its best. For the first time within that institution, 3 clean audits in a row. For the first time, even her worst enemies agree that the backlogs are at an all-time low since this institution was ever put into office or into place. In other words, nobody's saying she came there and she harassed people sexually, or she was drunk, or what, you know. Obviously, I'm just saying there are things that would require the intervention of Parliament, which are grotesque and unacceptable to all of us in society. But should a public protector, ombudsman, whatever you call it, be literally impeached for improving governance and delivery?
My answer to that would be no. And I also have a selfish reason for that. And my selfish reason is that, you know, I've been ombudsman for 18, this is my 19th year. We have come a long way in ombudsmanship in Africa. And the reason why I actually agreed to come here is because I felt that I can't allow us to go backwards to when I was appointed in 2004, you know. Let us strengthen this institution. Let us encourage other African countries to set up this institution.
Okay. Thank you. On that note, Ms. Sokoni and Advocate both, we will pause there
Thanks, Chair.
and adjourn our meeting. We will meet again tomorrow morning at 10.
Chair, just as
Yes.
a matter of housekeeping, can I ascertain from Advocate Mpofu how long he's still going to be?
I'm going to attempt to finish around about tea time, not much longer than that, but I'll try to yes, I know that's why there's one section, if you might have noticed, that I'm going to do mainly, which is the court cases, and the rest will just be cleaning up. So it shouldn't take that long. I'm mindful of the fact that not only there'll be questions from the evidence leaders and also from the members. So I will not abuse the indulgence of
That's
the chair.
fine. Thank you, Advocate Mpofu. Thank you, colleagues. Meeting adjourned.
Thank you.
Record.